Okay. Lords, yes, make one submission, my lord. Serial number 18. I'm seeking an adjournment, my lord, for some personal inconvenience.
Oh, it's a group of what is that? It is about what?
I have informed the other side.
My lord, it is high security registration plate. That is to be fixed on from cars, my lord. High
That-
security registration plate.
It will go in September,
Can it be on the first week, my lords?
12th September. 12th September,
Much obliged.
at the request of
Grateful, my
you are for petition appellant.
Appellant.
At the request of learned advocate for the appellant, Mr. So and so stand over to 12th of September as requested. As asked for.
Waiting for posting for tomorrow, my lords, education matter, counseling matter.
Tomorrow,
Yeah.
Monday not possible,
My lords, counseling date, my lords, is likely to end at the time.
likely to.
End, my lords. First round of counseling is going to be announced on the 21st. I have not been permitted to participate in the engineering counseling.
12th.
My apologies.
12th.
With your lordship's permission, my lords, I'll serve an advance copy of the respondent.
Lord, serial number 73, man. Pay for a week's accommodation.
73.
70.
It will go to September. At the same, at the request of, same date. 12th September.
No, serial number 94, my lords. Lords, senior citizens writ appeal, my lords. Lords, only office objection is color photographs of Lords, maybe dispensed with, maybe listed on admission, my lords. Office objection may be dispensed with him.
94. Office objections are dispensed with in relation to the production of color photographs.
Deeply.
The registry may list the appeal. Regarding what?
My lords, it is a compassionate appointment given to the respondent
On
on the 9th.
22nd August.
Deeply obliged. Deeply obliged.
Yes, ma'am.
Mentioning one matter, this one, serial number 4, you know.
4.
Serial number 4. I think I have counseled.
Today's-
Applying for the appellant, your lordship.
Today's board,
Yes, serial
that is-
number 4.
72 of 20.
Yes, that is it.
So what do you?
Seeking for a short accommodation in that.
22nd August. Send over to 22nd. Now, that's all.
Still number 1. Shruti Vaishali Hegde.
My lords, after filing the present petition, some subsequent developments have taken place, my lords. May I request for tomorrow, my lords? We will receive update by this afternoon, my lords. And if the grievance of petitioner is considered, my lords, we will withdraw the petition tomorrow.
This is regarding change of, my lord,
Hotel
the,
is closed or open?
till yesterday it was open. When he served the copy, I told them to go.
Very good. Tomorrow
Tomorrow, my lords.
or Monday?
My lords, tomorrow we'll
Tomorrow.
withdraw, my lords,
Tomorrow.
if it is considered. Obliged.
Yes.
Still number 2.
My lords, I appear for the
For
petitioner.
the petitioner, my lords. Serial number 2, my lords. And for
Uh,
petitioner.
My
Yes.
my lords, I'm the arguing counsel in this matter, my lords.
Sir, list 2 serial number 2, sir.
This is serial number 2 in board number 2.
Apologies, my lords.
Timothy Annapurna board.
So you are not appearing.
My lords, it's in serial number 1. I came in the wrong list, my lords. I apologize for that.
So this is who are appearing.
Yes.
For
For the appellant, my lords.
who is the appellant? Student,
Please, my lords. My lords, I have filed this.
not student. Who is the appellant? Rajiv Gandhi
Please,
University.
my lords.
Yes, what is the matter?
My lords, I have challenged the learned single judge's order, my lords. My lords, your lordship will get it at,
You are for whom? University.
for the university. My lords, what has transpired in this case is this, my lords, for academic year 2024 and 25, my lords, I have conducted an inspection of the respond number 1 college. My lords, after conducting inspection, there are deficiencies that has found in the respond number 1 college, my lords. Thereafter, I have issued notice to the respond number 1, my lords. My lords, after issuing notice, the respond number 1 did not turn up to give any reply, my lords, or any representation. The notice which was issued by me in December, my lords, of 2023, 14th December 2023, my lords. My lords, may I request your lordships, my lords, I may place the memo on record, my lords, of having issued the notice. My lords.
No, no.
What is wrong in this?
My lords, the reason is, my lords, I have not been able to conduct, I have given them a sufficient opportunity, my lords, for the respondent college. My lords, they have not submitted their representation back in them. My lords, now there is a direction by this Honorable Learned Single Judges Court, my lords, asking me to pass an order. I have no problem in passing an order, my lords. I have conducted inspection. Dean's opinion is also ready, my lords.
Do it
There was-
again.
My lords, there was a slight delay. The reason because the syndicate board members nomination was under challenge before this honorable court in writ appeal number 714 of 2024. That came to be dismissed only yesterday, my lords. We shall constitute the syndicate board meeting, my lords, and we shall pass necessary orders.
That is no ground. You can't rely on the pending litigation and
No,
the
my lords, it
outcome
is
and
disposed. My lords,
not,
it is
not
disposed.
announced yesterday. No, that is irrelevant. We only look at the order of learned single judge.
My lords, very well, my lords. My lords, what has happened is, my lords, my lords, the learned single judges has observed that I have not given him given the respond number 1, the opportunity of hearing. Whereas I have already given an opportunity of hearing, my lords, I may be permitted to produce the memo, my lords, for
Third
having-
learned advocate, Miss so and so for the appellant.
My lords.
Present appeal arises from this.
My lords, there will be cascading effect. My lords, along with the respondent number college, there are 70 other colleges whose affiliation was withdrawn. My lords, if this single judge's order is not stayed, all the 70 other colleges would also file similar writ petitions, my lords, where I have to pass an order. My lords, I am ready to pass an order. I have in fact conducted the inspection, my lords. I have placed the dean's opinion before the syndicate board members. My lords, it is a matter of time. My lords, I shall pass the orders. My lords, I'm only praying for 2 weeks' time for me to pass an orders. My lords, I'm only asking for extension of time for me.
Third learned advocate, Miss so and so for the appellant university. The present writ appeal arises from order dated 29th July 24 passed by learned single. In the writ petition paragraph, the petitioners were Benedict's Institute of Nursing, Asir Vanam, and the Asir Vanam Benedict Society. They prayed for setting aside of order dated 7/2/24 passed by the Rajiv Gandhi University for Health and Sciences, the appellant hearing. Yes, original respondent. By the said order, the affiliation of the petitioner institution for the academic year 2024-25 was cancelled. There is a further prayer seeking direction against the respondent to reopen the online portal for admission for the academic year in question. The petition paragraph came to be disposed of by a single judge. Whereby impugned order oblique impugned endorsement oblique order dated 7/2/24 was set aside. The full stop. The matter came to be remanded to the respondent for reconsideration afresh of the request of the petitioner for continuation of the affiliation granted in its favor for the academic year 2024-25. The petitioners are directed to appear before the respondent on 1/8/24 and submit the necessary pleadings to put forth its case. The respondent was further directed to consider the same by taking appropriate decision regarding continuance of the affiliation on or before 8/8/24. There is still another direction by a single judge whereby it is provided that in the event of respondent decides to continue the affiliation by passing appropriate orders in light of the order of the court, the respondent shall open the admission portal to enable the petitioners to give admissions. Paragraph, while passing the aforesaid direction to remit back the case and to afford opportunity to the respondent or original petitioner. It was observed by a single judge that the impugned order indicated that the appellant university had not given any opportunity to the respondent. And no notice was issued to enable the original petitioners to
My lord,
put forward that stand. In course of the hearing, paragraph, learned advocate for the appellant submitted that the opportunity was given. Be as it may, full stop. When the order did not record anything, it is not
my lords, may I make a submission, my lords?
possible for the court to go into the said aspect. The directions are only for remitting back the case and giving opportunity to the petitioners to put forward the case, to put forward the defense in the case in relation to the cancellation of the affiliation. Full stop. No interference is called for in the order in the directions of a single judge. However, what was directed was that the respondent shall appear on 1/8/24 before the university, and respondent as petitioner shall appear before the university on 1/8/24, and that university shall decide the issue of continuation of the affiliation, issue about the continuation of the affiliation within 1 week before 8/8/24. Since the said dates are passed by, it is provided that the respondent's original petition shall appear before the university on 13th.
My lords, 15 days time may be granted, my lords.
On 13th of, university shall call the petitioners as respondents hearing. On 13th of, on 12th of.
My lords, 20th, my lords, lords, 20th, my lords. 20th, my lords, 20th or 21th.
On 13th of
My lords,
August.
my lords, 2 weeks,
2024,
my lords.
and take appropriate decision as director of a single judge within 1 week thereafter, on or before 21st of August 2024. Subject to the above limited modification, the directions of a single judge are confirmed, the appeal is dismissed.
My lords, my lords, may I make a mention? My lord,
What is your quorum in the syndicate?
my lords,
What is your quorum in the syndicate?
I have to verify, my lords. My lords, may I make one submission, my lords? If the my writ appeal is dismissed, my lords, every other 70 other nursing institutions will also file the similar writ petitions, my lords. This will have cascading effect on other, on the students, my lords.
So instead of 13, you make it 20th, and instead of 21st, 28. Little more time is given. Yes, next.
Case number 3, Mr. Sagar BB.
On behalf of the state. But on the last occasion, courts had directed that an assessment be conducted, and the report be submitted. My lord. May I submit the report? Locomotor disability.
So 1824, some directions received.
On the
You are for whom?
Lord, I appeal for the
State.
state, for the state government,
State.
state government.
The direction was to the government medical college,
Government medical college, it's government borrowing in the Lady Cousin Hospital.
give to the council. Pursuant to order dated.
Yes.
1824. Advocate Mr. Dev Hegde submitted that the medical examination of the petitioner with regard to his physical disability, extent of physical disability, was undertaken by the team of doctors as observed and directed by the board. He produced the doctor's opinion. Panel of doctors' opinion, who were from and nominated by Sri Atal Bihari Vajpayee Medical College and Research Institute, Shivajinagar, Bengaluru, for the purpose of carrying out the directions of this court to medically examine the petitioner. The sealed cover containing the medical report, medical opinion, was opened in presence of all the learned advocates. The communication oblique opinion dated 6/8/24 indicated that the petitioner has 54% left shoulder disability with normal left elbow and normal left hand components. It is an admitted position, also noted by the team of doctors, that persons with disability between 40 to 80% are allowed. Full stop. In other words, if the disability is below 80%, comma, the candidates will qualify for admission in medical courses. Full stop. The opinion records thus last paragraph as per the above order. Satisfactorily pursues medical course. Any of the above opinion, comma. The factum is established that the disability of the petitioner is to the extent of 54% only, which makes him eligible and entitles him to seek admission in the medical courses. Full stop. The respondents are directed to consider the case of the petitioner, treating him to be eligible to compete in the admission process. Correct?
Yes, ma'am. Subject to other eligibility. criteria. Subject to other.
That is always there.
Subject to
Subject to other eligibility criteria. We have to.
Kelly, what did you? And give admission on merits, provided the petitioner
Yes, yes.
Yes.
satisfies the
Qualified,
other,
that's all. Yes.
other eligibility conditions.
Yes, yes. Deeply obliged.
The petition is allowed according.
Please.
Deeply obliged.
This number 4,
Where
Mamata Ji Kulkarni.
it's respondents 1 to 4 herein. Are the medical students, my lords, in their first phase of course of study who have successively, my lords, failed for 4 times? Please see page 35, my lords, of the paper book. The provisions regulating the study, clause 7.7, page 35. my lords.
Where is the order of learner single judge?
At page 14, my lords.
14. Interim order.
Yes, my lord. It could not have been granted, my lords. Matter is covered by Supreme Court's order. I'll just show, my lords. Kindly permit me to show page 35, my lords. 3.5, clause 7.7. No more than 4 attempts shall be allowed for a candidate to pass the first professional examination. The total period of successful completion of first professional course shall not exceed 4 years. Partial attendance of examination in any subject shall be counted as attempt. My lords, this was made by the Medical Council of India. Later, my lords, at page 55, the NMC also, my lords, provided for the identical provision. Page 55, clause 21. Clause 21, this is by the NMC. Provided under no circumstances, the student shall be allowed more than 4 attempts for the first year of professional MBBS, and no student shall be allowed to continue undergraduate medical course after 9 years from the date of admission into the course. But this provision was subject, admittedly, they have completed more than 4 attempts.
It's 77.7.
It's at page 245, my lord will find the order of Delhi High Court, my lords, which has gone into the validity of this provision and has held they are valid. Where at 21 of that, my lords, may kindly be seen. It points out the rationale behind this provision made at page 254.
Sorry, these are the hard learned senior advocate, Mr. So and so with learned advocate, so and so for the appellant university. This appeal is directed against order dated 5/8/24 passed by learned single judge, whereby the original petitioner is permitted to appear in the ensuing examination commencing from 9/8/24 for MBBS course.
Yes.
MBBS course.
5th attempt.
Full stop. While the the position obtained is that the order is not only an interim order, which is passed pending the main petition at large for consideration of merits before learned single judge. Learned single judge is observed that if the permission to appear in the examination is not granted, prejudice may goes to the petitioner if the petitioner may have to face irreversible situation in the event in the event he succeeds, he or she succeeds in the petition while permitting the petitioner to take the examination. Learned single judge has clarified that the result of the examination of the petitioners shall not be announced without leave of the court. Full stop. It is further directed that the learned single judge further required that the petitioner shall not claim, as further provided that the petitioners shall not. How many petitioners?
There are three of them.
Petitioners shall not claim any equity in this regard. Full stop. Reiterating the aforesaid conditions that the permission granted by learned single judge to appear to the petitioners to appear in the examination, as well as the factum of petitioner's appearance in examination pursuant the order, shall not vest in the petitioners, any of the petitioners, any equity or right, the court is not inclined to interfere with the order of learned single judge, as it does not determine any rights of the parties finally at this stage. Learned senior advocate for the appellant would invite attention of the court to
Page
the
240.
regulations. What is this? Regulations governing. Right. Regulations on graduate medical admission, medical examination, 1997 as amended in 2019 to rely on clause 7.7, which provide that no more than 4 attempts shall be allowed for a candidate to pass the first professional examination, as well as clause number 50, clause number 21 of the Graduate Medical Education Regulation 2023, which deals with the training period and the maximum duration thereof. Full stop. The said aspects are not gone into for their merits at this stage, as the court is not interfering with the interim order of learned single judge, which do not have the trappings of finality, since the dispute is at large to be decided finally. Full stop. The university is not precluded from relying on the said regulations at the time of final hearing in accordance with law.
It's only because it was covered by Supreme Court order we thought.
Not at least. So we are passing such orders then.
I know, I realize.
List one, contempt matter, seal number 1. Mr. Ramesh KR.
No, I appeal for the complaints in this matter note. Order passed by the learned single judge is at annexure D, my lord, page 18.
What is it about?
Learned single judge of this honorable court has directed the accused to consider the application submitted by the petitioner as per annexure A within a period of 4 months, my lord, even after lapse of more than 10 months, my lord.
Now this is regular work. Notice returnable on 26 September.
Much of this.
This a PL matter, seal number 2. Mr. Sanket Bisani.
My lords, I appear for the petitioner, my lords.
First response.
My lords, the PIL is primarily formulated to frame guidelines on perjury as to how a matter of perjury should be dealt There are 12 specific questions that the petitioner has outlined at page 38 of the petition. There are guidelines already there by the Honorable Supreme Court in Iqbal Singh Marwa and Pratish Singh's case, where these aspects have already been done by the Honorable Supreme Court. However, in Karnataka Civil Criminal Rules of Practice, Chapter 6 only talks about two steps, where Chapter 6, Rule 1 and 2, they are the only two rules which deals with preliminary inquiry and are not exhaustive guidelines as to how this matter has to be dealt with. Therefore, the petitioner has filed the present PIL only in order to safeguard or formulate guidelines and also conceal his name in the present petition so that his name is not seen in the present matter, enforcing his right to privacy, and just frame guidelines for the benefit of any litigant. And he doesn't have to undergo several years of litigation on a false pretext or a false case being filed on him. And some fear is instilled on filing false affidavits before this honorable court or any court in the state, my lords.
Of the CRPC, no?
Yes, ma'am. CRPC and also BNNSS, the similar provision that has been adopted here is 379, which is at page 16 of the writ. We have reproduced both because this was filed in April. At that point of time, this was not in force. Therefore, we had produced both these sections 340 and 379.
29 again, 229.
The context of both the provisions are verbatim, my lords. 340 and 379 is the same except the change of the section. There is no change in the section per se.
My lord, please take paragraph 2 of the writ petition. Then, my lord, it is a personal petition that has been filed. My lord, and my lord will get the answer, my lord, at paragraph 17, the first line, and then paragraph 21. It's not a public interest
It's a
litigation.
dispute between husband and wife.
Yes, my lords.
You are there. Please, my lord.
You are for?
The first respondent.
My lords, as an interim order, we seek to conceal our name. We don't seek to get an order only for ourselves with frame guidelines. We have already filed perjury applications at the trial court, which were pending consideration and have been decided. We will recourse the appropriate remedy of an appeal. However, we are looking at framing guidelines for the state. And as an interim order, we are anyway removing our name, by which we cannot use these orders in any other premise as it is. It is a matrimonial dispute, and the husband has gone through several years of litigation for a marriage which did not even last for a year. And the dispute is been going on for 5 years. Therefore, he doesn't want anyone else to suffer. He only wants the guidelines to be framed, which is there already in chapter 6, but they have to be elaborated. If the 12 questions are elaborated by this honorable court, my lords, the petitioner undertakes not to take any benefit, but the entire state, every litigant can take. The entire objective is that there is a fear instilled in litigants to not depose falsely, because if they depose falsely before this court, it hinders the entire administration of justice. And that is what we are here for. And those guidelines have nothing to do with his case per se. It will benefit everyone. We have stated about the matrimonial dispute as we don't want to conceal anything before this court. The rationale for him, there was an objective because he's undergone the trauma which would not have been done in case these were in place. And if they were followed in letter and spirit, the rules specify that 6 weeks have to be taken place for rules specifically specify that this case should be disposed within 6 weeks, but these matters have gone for 3 years for him. And they have just come for a finality of decision for which we will appeal. But however, if these guidelines are not formulated,
That yes. Yes, Mr.
my
Anything-
lords,
Anything
yes.
further?
We,
Anything
we,
further?
we wish to seek for an interim order for concealing the name of the petitioner and enforcing his right for privacy. And we seek this honorable court's indulgence to frame these guidelines for the state, my lords. The 12 questions have been imposed, and I could argue this matter and show what the courts have held in each and every judgment, my lords. And or notice could be issued and they could give their responses to how these guidelines could come through. In Swara Singh versus State of Punjab, the Supreme Court has stated that perjury has become a way of life in the courts of law courts. A trial judge knows that the witness is telling a lie and is going back on his previous statement, yet he does not wish to punish him or even file a complaint against him. Similarly, these guidelines were actually clarified by Pritesh versus State of Maharashtra, where the court has clarified with what an inquiry is. These are at page number 22 of my petition, my lords.
The pleadings in this public interest petition make a conspicuous reading. The petitioner, who is an advocate by profession, claims. Yes, Mr. You are muted yourself.
My lords, I'm not the petitioner. The petitioner is before this court. He is there. I am representing him. I'm the arguing counsel. The petitioner is before this honorable court.
You are not, petitioner is not advocate.
No, my lords, he is not an advocate.
Petitioner's father was an advocate.
His father was an advocate.
All
Yes,
right.
he
Makes a
is before this court now, currently.
conspicuous reading. Full stop. Besides claiming that the petition is put forward without involvement of any public interest, private interest, and that the cause in the petition pleaded, cause pleaded in the petition, cause advanced in the petition is a public cause and in public interest, comma. It is stated that the father of the petitioner was an advocate practicing in this high court. The petitioner proceeds to state, comma, then inward comma. Continue. The petitioner has filed the present PIL after his matrimonial dispute, and to ensure no one else has to go through what the petitioner went through, inward comma ever. It is the case of the petitioner, inter alia, that his marriage lasted for 370 days. The option is available to you either to invite the order or take the other recourse, Mr. Counsel.
My lords,
So we are making very clear, loud and clear, that the option is available.
yes,
One
my
is to
lords,
invite-
but however, if we would only want to plead one thing, my lords, that this is in public interest, in genuine public interest. We don't seek any benefit out of this order per se. We genuinely believe that this could.
That we have learned and understood, but the option is given so that you may not have the grievance that the order was started without asking you.
My lords, withdrawal of the petition would the entire purpose would get defeated. But if this honorable court believes that
That
if
is
that
lasted for 370 days, during which the wife of the petitioner resided with him in the matrimonial house for 250 days. Thereafter, she left the matrimonial house on 12/9/18. And that the disputes are pending between the spouses, It is stated that the petitioner's wife has filed several cases. It is claimed that it is alleged that the petitioner's wife has filed several cases on false premises. Clearly mandated, which is, according to the petitioner, contrary to the material on record, and that they are filed in order to abuse. And they are filed, which is then a comma, inverted comma, in order to abuse the one-sided laws that are benevolent toward women, plural, WMEN, inward comma over, full stop. With such basic premise, comma, the prayers made in the present public, in the present petition are manifold, essentially are manifold. The first prayer is to issue writ of mandamus or any other appropriate writ to all courts within the state of Karnataka to clarify the procedure for the courts to adopt while an application for perjury is filed. The second prayer is to lay down the guidelines while for interpreting the terms preliminary inquiry and inward comma, preliminary inquiry, and again inward comma, expediency in the interest of justice. The third limb of the prayer is again to issue writ on all the courts within the state to convert the application for perjury to a fresh case to be sent to the magisterial trial. The fourth prayer is made whereby directions are issued, are sought against the courts within the state of Karnataka to stay the main matter until the perjury case is decided. It is the fifth prayer, again to direct the courts in the state to expeditiously dispose of the press case of perjury within stipulated time. The sixth part of the prayer is to set up the fast-track special courts to decide the application for perjury. Full stop. It is claimed that the petitioner has approached the court with a pure question of law, comma, for larger public interest, comma, to lay down the law in respect of Section 340 of the Code of Criminal Procedure 1973, and Section 379 of the Bharatiya Nagariks Suraksha Sanhita 2023. While the avowed claim of the petitioner is public interest in seeking the aforesaid prayers, comma, in the backdrop, there is only a grinding of private interest by the petitioner. Full stop. Noticeably, comma, interestingly, and deprecably, comma, the factual background as pleaded, factual background to advance such a prayers as pleaded by the petitioner himself in this petition is as under. Then quote the paragraphs.
My lords, if I may interrupt, if I
Quote
may,
the paragraphs. Paragraph 8,
uh,
9, 10, 11, 12, 13, 14,
My lords, if I may be permitted to withdraw the petition, my lords. With liberty, withdraw the present PIL, my lords.
we can't take at the dictates of the advocates, Mr. Counsel. We are not known to the acting on the dictates of the advocates. And whenever you want something, you seek something. Whenever you want withdrawal, you seek withdrawal. That is not the practice. Please desist henceforth. Otherwise, we will take a very seriously against your own advocacy. Dismissed as withdrawn.
Oblige, my lords.
This is not the way to deal with the High Court and the public interest petition. Very unfortunate that you are bringing such kind of frivolous petition, purely guided by personal interest. Yes.
This is number 3. Iran Krishna Swami.
Yes.
One of the oldest extensions of Bangalore is Basavanagudi. In fact, it was the first extension to be formed. And the name is known for the last 140, 50 years. The state of Karnataka we filed objections, we sought audience, rejected. Then we took out a procession and government extended police help to us to take the procession up to Vidhan Sauda, and gates were closed at Vidhan Sauda. We are not allowed to make our representation also. And it conflicts with the concept of secularism. Matter requires consideration in view of the 9 judges decision in S.R. Bommai. That is the ground number 1 raised.
Sorry, the petitioners in this public interest petition, 6 in numbers, are claimed to be the residents of the Bangalore of the ward known as Basavana Gudi, now renamed as Doda Ganpati. The grievance of the petitioner is that the respondent state of Karnataka and the chief commissioner Burhat Bengaluru Mahanagarpalika are responsible for changing the name of their ward from Basavagundi to Doda Ganpati. It is claimed that the name Basavagundi has historical and cultural importance, and the residents are And it is a matter of pride for the resident that the ward belongs to the renowned persons. Full stop. It is claimed that it is prayed that the notification dated 25/9/23 where is that? Issued by the Urban Development Department of the state government, changing the name of the ward from Basavagudi to, what is that? Dodda Ganpati may be set aside. Full stop. The figure, the notification figures on record at annex, at annex 2, page 50, from which it could be seen that the respondents have changed the name of the several wards, city of Bengaluru. Full stop. Even otherwise,
Your
comma.
Lordship, please
The-
refer to ground number
The-
1, Milord.
The subject matter regarding the change of the name of the ward or city cannot be formed part of agitation in the public interest litigation. Full stop. No public interest is made out to grant any relief whatsoever to the petitioner. Full stop. For several names of the several wards are changed. ऊपर लिखा है ना, वहाँ add करो. The notification further reveals that the delimitation process of changing the boundaries of the wards in the city is underway in exercise of powers under section 7 of the Third Bengaluru Management Palika Act 2020. Paragraph. Then full stop. No case is made out for, so whatever.
Regarding ground number
Petition
1, one
petition
sentence.
is summarily dismissed with cost of rupees withdrawn.
One sentence about ground number 1.
Sorry, come with the better matter, Mr. Council.
Better.
For urgent, serial number 5, writ appeal by state.
My lord, I appear for the appellants, my lord.
I appear for the counsel for the respondent number 1, my
Sir, you are the only respondent?
No, my lord, respondent number 2, notice will have to go to respondent.
Notice returnable on. What is it about?
My lord, this is a case, my lord, where the respondent number 1, my lord, is seeking for, my lord, payment of pensionary benefits. My lord, he was appointed by respondent number 2, my lord, without seeking approval from the government.
Notice returnable on 24th September.
Correct.
This number 6. Somali Patil PS. May I please? I appear for the complaint. Now, this is a case where
Of the learned single judge, my lord, the institution as well as the state government, both of them have filed a writ appeal. They have been tagged on to the contempt.
I request the court to kindly permit me to show the disobedience of the order, which is complained of, is at Annexure A, page 14.
They are the nurses, staff nurse.
Yes.
Staff nurse. We were appointed in the year 2008. Uninterruptedly, we have served. And several rounds of litigation. Every time we file a case, they come and tell this honorable court that they are going to regularize our services. Time limits after time limits are set for considering our cases. And they even filed an affidavit in the case on hand, saying that they will regularize our services. So regarding the entire thing, the learned single judge disposed of the matter. Thereafterwards, we have given umpteen number of representations. It's so,
Petition.
sorry,
You are for whom?
complainants.
Complainant is.
In
Appeal is
the
to
ca-
be-
But I am for the appellant, the
You are for
institution.
appellant.
Yes, my lord. The
So this order is
date
based on
has
some other
also
order.
not,
This order is based on some other order of this court.
Sir, may I request the court to kindly take the contempt
Number 3405.
of court case
Appeal.
575.
the
Now we
appeals
hear
and
the appeal itself.
appeals may be
Very
not heard, my lord. Today, my lord,
Very,
I'm told,
But that-
AAG has some inconvenience, my lord, and.
no, I oppose any adjournment in the matter.
Correct.
This has been going on repeatedly.
Not by the state government and matters are
You are
before
there.
the court, my lord.
You are there.
I'm only, my lord, I'm only supporting the state government. State government is the authority, my lord, who have to regularize the services of the petitioners, the complainants.
That issue is also settled by,
Is by whom? Appeal is by whom?
My lord, appeal is by the government also, my lord, along with the institution. Our
By-
appeal is at
by the court,
6
my lord, both.
My lord, there is a delay of 502 days in filing the appeal.
So all are appearing.
My lord, we all are before my lord. My lord, the
Review a petition was filed, my lord, before the learned single judge. But after the
To appear for
disposal,
all the
yes,
petitions.
my lord, it is, review was dismissed and thereafter an appeal is filed. Under
Is
these
that I-
circumstances, my lord, there is a delay of.
my lord, notice may have to go to the private respondents,
All
my
are
lord.
appearing, then we may advert to the delay aspect only. If all are appearing.
no notice is ordered was in the appeal so far.
Notice.
Now, may I request the court to kindly permit me to show in the contempt petition? Why?
Doing notice in appeal, both will go together.
No, with great respect, they did not file any appeal. The government did not file any appeal. It is only after this honorable court has directed charges to be framed against them, they filed a review.
6.2, my lord, is
Thereafter.
the appeal by the state. 6.2, my lord.
Kindly take the order sheet in the contempt case. I'll just show their conduct, whether they deserve any further indulgence in the matter.
Appeal we are going. And delay we are going.
But everybody is appearing, then we may consider the delay aspect and take up the
Yes.
appeal immediately. Thereafter.
Because I'll have to file a formal objection.
All right, file of, notice returnable on.
Second case, they have not served the no.
28th of,
My lord, I undertake to do that.
28th of.
ಇವತ್ತೇ
Right,
notice.
Counter to the application for condolence and delays to
No,
be
but
filed,
wait.
the same may be filed before the next day.
May I draw the attention, only one statement that was made to the court. Kindly take the contempt of court proceedings for a minute. Whether they should be given any further time. Sir, the order sheet dated 22/2/2024 may kindly be perused.
Something in contempt.
22.
22/2. 2024. This is after they filed an affidavit that they will regularize our services. They took time. Direction was issued by this honorable tribunal, honorable court.
In reverse order or?
16 years we have served, sir. 16 years we have served without a break in service. Kindly see the order dated. Sri so-and-so learned additional advocate general. 6 weeks time to complete instructions. Report compliance, kindly mark it. And to report compliance.
They have filed appeal, will consider.
The same is opposed by so-and-so. As a final chance, a week's time is granted, making it clear. If compliance is not reported, appropriate orders will be.
They should be permitted to contest their. Yes.
For 16 years we have served, sir. We are COVID warriors who were continued on a specific undertaking that will be regularized soon after COVID.
We'll consider along with the.
Next week it may be called. I'll file my objections.
28th of August.
October.
August.
All right, very good.
Number
You may be directed to serve the copy.
Malad, I'll do that, Malad, I'll do.
Number 7, appeal by state.
And for the complainants, my lords, the contempt petition, my lords. Copy of the
Malad, I'll serve.
appeal memorandum is served upon us, my lords. And for the complainant in the connected contempt petition, my lords. The government has filed a writ appeal.
Writ appeal is when it is listed today.
It's listed, my lords. It's at serial number 7.
24.
Delay is there.
Malad, 151 days delay.
Then notice. You are the only respondent.
No, my lords, there are other respondents as well.
Notice written on 25th of September.
May I request for a copy, my lords? Writ appeal.
Malad, I will.
Given. Copy will be given.
Number 8, to Gopal BV.
So 92 days delay, notice returnable on 25th September.
Permit me to serve the copy to the learned council. And permit me to serve the copy to the learned
They will
council.
serve. Otherwise we will serve.
Hello?
If they don't serve, we will serve.
Yes.
These requests not to be made to the High Court.
This is number 9, Ranjan Kumar.
Delay of 825 days.
Yes.
The question in this matter, my lord, the Kumki land, my lord, it is a government land. Under section 79 of the Karnataka Land Revenue Act, my lord, the cultivate adjacent to the Kumki land, my lord, have got the right to enjoy this property. And the first appellant, my lord, has grown the mango trees in an extent of 1 acre of land in the Kumki land. Now, my lord, the said land is sought to be extinguished from Kumki, and the same is going to be allotted in favor of the Gram Panchayat for the purpose of allotment of sites.
What is
The,
Kumki?
my lord, it is a government land, my lord, in South Canara, section 79, my lord. In South Canara, my lord, the Kumki, my lord, adjacent to landowners, they can enjoy this property. Such a right, special right has been recognized in section 79 of the Karnataka Land Revenue Act. My lord, we have been enjoying this property. As a matter of fact, the first appellant has grown the mango trees. Rashmi, kindly say annexure M. Even there is a findings by the authorities to the effect, my lord, that I have grown the mango trees. Page 96, my lord. Page 96, my lord. There are mango trees. Annexure C next to.
So inquiry was conducted, you were heard, you were
Alright,
told.
therefore,
you are
my
going
only
to-
observation I'm seeking my intentions of my Lord, my lord. Now I have made an application for regularization in form number 57. I have filed the application along with the application for production of additional documents. My lord, till my application is considered for regularization, my lord, let them not take any action, my lord. Now the learned judge, my lord, is of the opinion, my lord, the right of the appellant has not been crystallized. Now, my lord, I have made an application for regularization. It is permissible under section Rule 108 triple C of the Karnataka Land Revenue Rules. 108 Land Grant Rules. Land Tenure Rules. I have made an application, my lord. My lord, Shima kindly say, my lord, Rule 108 triple C of the Karnataka Land Revenue Rules. My lord, there is a provision for regularization. I have made an application for number 57. Shima kindly see, my lord, my application at page 200.
The lands known as Kumki lands, not common, are those lands which are situated adjacent to the private lands. Full stop. The owners of the adjacent lands are often given an extended. The permissive user of the Kumki land, which are adjoining, they are the temporary rights accorded to the persons to use the land. By order dated 29/11/21, the Deputy Commissioner, Dakshina Kannada District, Mangalore, passed order whereby the Kumki rights over 26 acres of land in survey number 127/1 in the Heru village, Mangalore Taluka of the Kannada district came to be removed. The purpose was to reserve the said land to be allotted as house sites. By the Peru Munde Gram Panchayat to the eligible needy claimants. The petitioners felt aggrieved by the said order and approached learned single judge, approached this court by filing writ petition number 23629 of 21. In the writ petition, the prayer was to set aside the aforementioned order of lit, order dated 29/11/21, passed by Dispon number 2, District Commissioner. The case was that they were utilizing the survey number, which was Kumki land, for their agricultural activities. And that the order, therefore, removing the Kumki rights could not have been passed. Learned single judge dismissed the petition. Therefore, the present appeal by the appellant or even petitioners under section 4 of the Karnataka High Court Act 1961. consideration of the order dated 29/11/21 aforementioned, which was impugned to Polana single case. It was recited therein that it was proposed to exclude the Kumki facility in the said land for the reason that the land was needed for the purpose of allotment of house sites. It appears that the Panchayat Development Officer of Perumudu Gram Panchayat, Bangalore, had requested the Tehsildar Bangalore to reserve 6.26 acres of land in survey number 127/1A in Utheru village for the aforesaid purpose. Thereafter, the Tehsildar conducted inspection. And submitted the proposal with his recommendation. Paragraph. It could be further noticed that received to the petitioners Kumkidars the time was also granted to the petitioners to, at their request, to put for their case. Learned advocate for the petitioners appeared in the final inquiry process and submitted the objection for exclusion of the Kumki rights from the in the land in question. In other words, paragraph. The inquiry leading to report for exclusion of the Kumki land, Kumki exclusion status, exclusion of the land from the status of Kumki to be utilized for the purpose of allotment of house sites to the needy persons was undertaken in compliance with the principles of natural justice, where the petitioners had opportunity to put forth their case. Besides paragraph, the petitioner as Kumki Das had no vested or permanent right in the Kumki land by virtue of the very nature of the land, which were given for temporary use only for the reason that they were that the land was located adjacent. Full stop. The petitioner could hardly claim any permanent right over or in respect of the land. The land, the Kumki land, is now proposed to be utilized for a public purpose for allotment of house sites to the siteless persons. Learned single judge was eminently justified in accepting the case of the respondents in justification of the impugned order dated 29/11/21 to observe that the petitioners do not have any indefeasible right to remain in possession of the Kumki land. Learned single judge further reasoned that the petitioners, even if they have utilized the land for cultivation of their Varga, VARGH, Varga land, they are mere licenses and no right is crystallized in their favor. Paragraph. The petitioners, the appellant's petitioners do not have any enforceable right in the land to call in question the order dated 29/11/22. Full stop. No header could be booked in the order of learned single judge. Paragraph. The appeal stands meritless and the same is dismissed.
My lord, we have made an application for regularization. It is permissible under 108CCC.
You can pursue.
When, my lord, such an observation, okay, it doesn't come in the way of considering my application for regularization. Because rule, my lord, permits me to seek for regularization of the government land if it is an unauthorized occupation.
You can pursue if you want.
Complaints
You could have filed the appeal. If you wanted to pursue the application. Yes, next.
Number 10, complaints in contempt matter. YS Aruna Kumar.
This matter, we have filed a compliance affidavit. Compliance affidavit has been filed, my lords.
Your lordship, the compliance is not even 10%. If I draw your lordship's attention to the learned single bench judgment,
The order passed is at page 9 of the compliance affidavit, my lords. The translation.
your lordship, may I be permitted to draw your attention to the judgment of the single bench in my contempt petition at page number 16, where the learned single bench judge directs the accused respondent to implement the inquiry report pending before the accused respondent since 2021. Since 2021, the inquiry report is pending and a copy of the inquiry report has not been served to me till date, Your Honor. I have sought it through RTI application also, which is pending before the accused respondent. Unless I get a copy of the entire inquiry report, I cannot file a counter affidavit. Hence, I request your lordship to direct the accused respondent to issue a copy of the certified inquiry report, which I have filed for through an RTI. Unless I secure the entire inquiry report, I cannot file the counter affidavit, your lordship. Hence, I kindly request your lordship to direct the accused respondent to issue a copy of the entire inquiry report so that I can get it translated, because this inquiry report relates to a multi-crore corruption scam between the department officials and the two unlawful managements of the college, your lordship.
For learned party in person, Mr.
Arun Kumar YS.
Kumar YS, who himself appears as complainant, and learned
AGA,
additional government advocate, Srimati
Pramodini Kishan.
Pramodini Kishan for the respondents. By filing this contempt application, the party in person complained of the non-compliance of the following directions passed by learned single judge in the order dated 9 August 2023 while disposing of writ petition number 17946 of 2019. So quote paragraph 5. As per the above direction, the number 1 as competent authority of the was directed to consider the report and to pass the appropriate orders within stipulated time. The prayer in the writ petition was to direct dispend number 2 and 3 over the commissioner of university education and the deputy director, Department of Pre-University Education, to conclude the inquiry and submit the report. It was in that context of the prayer, the aforesaid directions came to be issued. After filing of the after issuance of notice, correspondent appeared and has now filed compliance affidavit dated 22/7/24, which is affirmed by one Ritesh Kumar Singh, son of SM Singh, holding the post of Principal Secretary to the Government from a Department of School Education and Literacy, Bengaluru. He has stated in the compliance affidavit that in compliance of the order passed by the court, the inquiry was conducted and conducted by the department. Full stop. It is further stated that the inquiry report was forwarded to the government. Test response number 1. Full stop. It is next stated that having considered the inquiry report ordered dated 19/7/24, bearing number ED 155, DGW 2019 is passed. Full stop. The copy of the order is produced along with the adjournments to the above effect found in paragraph 3 of the compliance affidavit. Paragraph. It is stated in the next paragraph of the affidavit that the said order dated 19/7/24 is passed, rejecting the request of the complainant to be admitted to the grant in aid as English lecturer in place of one Srimati G. Vinutha, who attend the superannuation. It is stated that the request of the petitioner was not liable to be acceded to in view of the Karnataka Free University Education, into brackets, academic, registration, administration and grant in aid, etc., etc., bracket over, rules 206. Full stop. Complainant, it was stated, there is resignation on 29/11/2020, which was approved by the management in 2001. Paragraph. In other words, the inquiry is conducted and the order is passed, dated 19/7/24, as above. This marks the compliance of the directions of learner single judge. Nothing more survives in the
May I draw your attention to
contempt proceedings. Full stop. If the party in person is aggrieved on merits in respect of the order dated 19/11/19/7/24.
Your Lordship,
Open to the party in person to institute independent press proceedings. In accordance
Your
with
Lordship, I have not been, sir.
considered on its own merits, for which this court does not express any opinion on merits.
Your Lordship, I have not been served with a copy of the enquiry report, Your Lordship, to file a counter affidavit. This is a multi-crore corruption scam. I have fought for 10 years, Your Lordship.
Ask for copy and they'll serve.
Copy is not served, Your Lordship. Three weeks time to file a counter affidavit. Please, Your Lordship, I fought this a lot. 3 weeks time to file a counter affidavit.
Contempt proceedings are disposed of and not surviving. Paragraph. At this stage, learned party in person stated that the copy of the report is not given to him. Full stop. Learned, you will forward that.
Please.
Learned additional government advocate responded to state that the copy of the report shall be forwarded within 10 days
Please,
by registered ID post
please,
to the
complainant.
to the party in person at the address, at his address mentioned in the post title of the petition.
This number 11,
Uh,
Ramesh KR.
To you.
Next date, my Lord.
No date.
Short date, my Lord, please.
It is over. Proceedings are over.
I have fought this for 10 years, my Lord. It's my service conditions. It's a multi-crore corruption scam. There is clear suppression of factual matter because they have not submitted the enquiry report at all, my Lord.
The contempt proceedings are concerned. They are over. You can institute press proceeding to challenge the order.
No,
That
your
is the law.
contempt itself is not, compliance is not done to the single bench judge, Your Honor. It is not complied, Your Honor, fully compliant. 10% of compliance is done, Your Lordship.
Now it is over. Yes. Next.
Mr. Ramesh KR, 11.
I prefer the complaint in this matter, my lord. Lord,
What is it?
compliance affidavit has been filed, my lord,
Filed.
wherein some incorrect statements have been incorporated. In fact, my lord, the
What is the order? We are in contempt
Page
jurisdiction.
Please.
99, my lords, of the
Effecting khata in favor of the petition.
Please.
In accordance with law.
taking.
In view of the observations made at an XRM. What is an XRM? Let us see.
XRM is order passed by the deputy.
An XRM is at which page?
Annexure? Good.
Assistant Commissioner order. Complaints of deputy also.
Hmm?
Where is an XRM?
Lord, in the contempt petition, my lord, it is annexed as annexure I am referred to is annexed as annexure K in the contempt petition, my lord. Page number
It's
86.
27/9/23.
Please, my lord. Please, my lord, annexure K. Lord, this is an order passed by the Assistant Commissioner, wherein, my lord, Assistant Commissioner has directed the Tahsildar to effect the kata of the property in question in favor of the petitioners. Lord, in fact, at the time of we submitting the application,
The
my
order
lord.
portion may be seen, my lords, annexure K. Page 95 and 96.
Now, there is a clear direction to
To the
the
Tahsil.
Please,
Tahsildar
please.
to change the khata in light of the order.
No, my lords.
Now, my
To
lord,
consider,
one submission.
lords, may I read?
Let us see. Now,
Has
my
been
lord,
regarding the land in survey number so-and-so extent of 3 acres land in Kurubrahalli village, Jagan Kote, Siddhagatta Taluk has been sanctioned in the name of so-and-so. I have directed to order to the Tahsildar Shidligatta to change the kata as per the rules and verify the possession experience.
Yes.
They said, my lords, it has to be examined as per the law. Lords, the same has been done, my lords, as per annexure R7, my lords.
R7.
R7 of the compliance affidavit, my lords, page 45.
Yes.
my lord,
it
may I
is over.
draw your lordship's attention. My lord, your lordship may kindly peruse the order at annexure H, my lord.
We are in contempt jurisdiction.
Please, my lord.
Cannot examine the merits of the order.
Please, my lord, for a moment, my lord, your lordship may kindly peruse their own annexure R5, my lord, para 8. In the affidavit, my lord, they say that the original documents are not available in their office.
We are not adjudicating that order.
Now, my lord, on the one hand, my lord, in order to avoid this, my lord, they say on the one hand that they don't have the original records in their office.
These arguments in your independent proceedings.
My lord, on the other hand, my lord, they themselves,
That is not the subject matter.
they accused, my
Heard
lord,
learned advocate, so and so for the complainant and learned additional government advocate, any issue for the respondent. The present contempt petition is directed, is in respect of alleged non-compliance of directions of learned single judge passed in order dated 13th December 23. Direction read as under, extracting from paragraph 4 of the order. So having taken note to answer of this order. Red bracket. The operative part of the order dated 27/9/23 paragraph. In accordance of which the directions were to comply with was as under. Then it is at page 90. 90. At page 95. The blue bracket regarding the land upset possession experience. Therefore, it is clear from the above observation in the order dated 27/9. 23 paragraph. In accordance with the directions of the applicant, the petitioner has filed a petition for the completion of the 23 passed by the Assistant Commissioner, Chikkaballapura Subdivision, Chikkaballapura, that the exercise relating to change of khata was required to be undertaken as per the rules. And after verifying the possession experience, full stop. After issuance of notice in this petition, compliance affidavit is filed by the Tehsildar
Sidligat.
Gatta Taluka. Full stop in the affidavit. Where is that affidavit? In the affidavit, along with the, in the affidavit, along with the affidavit, comma, order oblique endorsement dated. What is the date? 11/6?
3/4/2024.
3/4/2024 is produced. The full stop. It is in vernacular along with the copy furnished in English. Full stop. The order reads as under. What from page 27? This reference. After examining, furnished to you also. It is further observed and second time. Xerox copy of the grant process. And Siddharga Taluka, full stop. The above order marks compliance of the directions. Nothing survives in this contempt proceedings. In the contempt proceedings, full stop. At the request of learned advocate of the complainant, it is observed at this stage that if the complainant is aggrieved by the procedural order, it will be permissible for the complainant to institute independent proceedings to challenge the order to be considered in accordance with law and on its own merits, for which this court does not express any opinion.
Bill number 12. In this matter, I seeks for a week's accommodation. Reply is ready, my lord. I'll file it in the registry today.
What is it?
Complaints submitted have been filed.
I'll file my
The
statement.
direction of the learned single judge was to consider the representation filed by.
Decided?
Yes, it is decided.
Decided?
Yes, Your Honor.
Where is that?
It's a forest land.
It's
R1, Your Lordship.
R1.
Is the letter that is sent with the Tehsildar to the Assistant Commissioner to initiate appropriate action. Thereafter, Your Lordship, R2 is the letter in which the land was reserved as a state forest in the year 1912 notification itself, Your Lordship. They are not in possession of the land, and there is Nilgiri growth. Eucalyptus trees have been grown over there, which is a forest land, Your Lordship.
What you decided?
The page 2, Your Lordship, of the compliance affidavit.
It was regarding what?
The petitioner is given liberty to submit a detailed representation with all the particulars to respondent number 3 and 4.
What was the representation?
To conduct Podi and Durust.
Conduct Podi.
Podi and Durust. That land is a forest land, Your Lordship.
So donate or not?
Notified forest land.
In respect to the land.
Yes.
My submission.
So the undertaking?
But the petitioner herein had requested for conducting Podi. Learned single judge of this honorable court has directed them to fulfill the formality within the specified time. Now, my lord, when at this stage, the land in question is admittedly standing in my name, and various other persons, the respondent authorities have granted and they have affected the kata. Now, my lord, the land in survey number 106 declared as forest area in the year 1997. Till then, it was not a forest land. My grant was in the year 1997, my lord. But I'm ready with the documents, my lord. I'll place it on record for the.
This is not the adjudicated process.
Please, my lord, on the face of it, my lord, what
Then permit you go on to produce the documents and answers and rejoinders and sub-rejoinders.
my lord, in order to substantiate that, the affidavit filed.
Not substantiate. Once it is a compliance and substantiating compliance, we'll close the proceedings.
My lord, on the one hand, my lord, they say it's a forest land.
Sorry, the directions of learned single judge in order dated 4th March 22, while disposing of the writ petition was to direct the respondent 3 and 4, who were the Tehsildar and the Deputy Director of Land Records, to consider
The
and
representation.
decide the representation of the petitioner. What was prayed in the petition by the petitioner was to conduct the Phodi and Durasti in respect of land bearing survey number 106, situated at
Sonde Bavi village.
Sonde Bahi village, Govri,
Bidnur Taluk,
Idannur Taluka,
Chikballapur,
Chikmagalur district,
Chikballapur.
Chikkaballapur district, Chikkaballapur district.
Chikballapura district. Along with the compliance affidavit, the respondents have produced copy of order oblique endorsement dated 13/5/24, which is in the nature of, which is addressed by the Tehsildar, Gauri Budur Taluka, to the Assistant Commissioner Chikaballapura. The contents of the same indicates that the process of conducting Phodi and Durasti was undertaken by the competent authority. However, the area was
Notified
found to be the reserved for forest, as per the state forest notification. Is it correct?
Yes.
Reserved for forest.
Yes, yes.
As per the state notification dated 1913, 1913. Despite the said fact, the Bagar Hukum community, it was observed, has granted the land and transferred the khata, and new survey number came to be assigned after Durast. That the same is notified for the Forest Department. Paragraph. The above exercise marks compliance of the directions, the doctrine of substantive compliance will apply. Nothing survives in the contempt petition. Full stop. If the grievance for the complainant subsists on merits, it is always open for the complainant to institute independent proceedings to challenge the decision and the opinion of the decision oblique opinion of the authorities to be considered in accordance with law on its own merits, in respect of it, this court does not express any opinion. These proceedings are disposed.
Particularly the annexure R1, the order dated 13/5/2024.
Next.
So number 13.
I appear for the government, my lord.
Pardon?
There is an interim order. Interim order from 6th of October 2016, my lord, to issue permits to me, subject to, my lord, payment of royalty, etc., and 20% bank guarantee. Till February this year, they have complied, my lord, and all of a sudden they have closed the portal. Then I have filed this application, my lord, under 39(1)(a).
My lord, may I make one submission? My lord, there are certain subsequent developments that have taken place wherein I have been instructed to submit that the portal of the petitioner has been opened. My lord, I have sought for that information in writing. So if my lord could grant me some time, my lord, I'll place it before my lord.
What is open?
The portal
For applying the permits, my lord, there is a
applying for the
portal.
permits has been opened.
It has to be online. Permits must be applied online.
They can apply and get the things.
My lord, the portal is opened is what I was instructed to submit, but since I have to get it in writing, my lord, if my lord could accommodate me for some time, my lord, I'll get the instructions, make my submission, and then my lord can proceed for,
It is
my lord,
called,
the order.
if it
14th.
get,
14th of this month.
Huh?
14th. Wednesday. Very well. By then they can file that in writing and issue permits in compliance with the order.
For applying for what?
My lord, it's under process is what I'm informed now of opening the portal. So if my lord could have it somewhere on 21st or 22nd.
No, my lord. My lord, the permits,
I don't know. Right?
the
When the present writ petition comes up for consideration from a learned senior advocate, Mr. Rao. Emphasize the order dated 6/10/23.
yes,
16
16.
to submit that there is a non-compliance of the order and that the petitioner has to file interim application seeking initiation of contempt proceedings
Yes.
Yes.
against the authorities. Full stop. In response to this submission, it was stated by learned additional government advocate Srimati Neelofar Akbar that as per her instructions, the portal of the authorities permitting to lodge applications
Is under
for
process.
iron array, for grant of iron array lease.
No, my lord.
For
permit.
transportation, my lord.
Transportation of.
For
Yes.
transport permits.
Permits for transportation after receiving the
Likely
necessary.
to be opened.
My lord, it's under consideration.
Opening of the portal for for permitting the applicants to submit their transport permit applications is under consideration. Full stop. She wanted to take concrete instruction in that regard. For that purpose, she prayed for time. Period of time is granted, stand over to
21st.
My lord,
21st of August.
13th or 14th, Lord, because the reason is this.
Lord, if I don't get, I'll again have to move for an adjournment. I don't know.
Writing from here, my lord, in Bangalore, may make only one submission, my lord, without taking much of your lordship's time. My lord, from 6/10, my lord, 2016 till February this year, they have obeyed. All of a sudden, they have stopped. From February, my lord, I am struggling. I have been facing, my lord, several litigations, my lord, for non-supply of granite blocks.
Procedural thing you've been for.
Only one letter to be produced. It is open, that's all.
Let us see on.
My lord,
14th.
because, my lord, this
14th.
Saturday, the office is not working. That's the reason why it's a second Saturday. So I may not get the instructions. That's the reason why I was
My
requesting.
office is not working.
Second Saturday is holiday, government holiday, my lord.
My lord, they
Government
have
offices
11,
don't
12,
work.
13, 14.
See on which-
One small letter, my lord.
My lord, if they give me a small information, my lord, the transport permits will be issued. Only thing is, they don't want to provide me with the invoices. The moment they provide me with the sale
So that-
invoices, my lord, we will give them, my lord, the transport permits.
They will wait for your opening of the port.
Well,
My lord, for 6 years, every month I have produced, my lord, the documents are so bulky. I don't want to trouble the
We'll
court.
see on, we take a call on 14th. Let us-
14th, my lord. May I make one small submission. Interim order is dated 6/10/2016, not 16/10.
6/10, 2016.
16. Yes, my lord.
16. Oh, this is old matter.
Old order, my lord, continued till the disposal of the writ petition to avoid the Supreme Court judgment, and they obeyed for 6 years. From February, they are harassing.
You find out something.
my lord, I'll do.
Unless, instead of precipitating the thing, you find out. Yeah.
Bill number 14,
Flash, my lord.
For the petition.
V.S. Srinivas.
Where my lord was filed, state road completion work, my lord, which was in 2017, which was taken up by the respondent. My lord, till today, my lord, it is not been completed. There's an affidavit filed, my lord.
Submission, my
My
lord,
lord,
in this
let me complete my arguments,
The
my lord.
petition and the prayer.
Learned friend does not allow me to talk. I'm only submitting what this PIL is filed for, my lord. Today also, they file an affidavit, my lord, that 99% of the work is completed. Another 1% work is still not completed because, my lord, in March, my lord, they had already filed an affidavit saying that in May, they would complete the entire work. Till today, my lord, the work is not been completed. 2017 is the contract which was entered between the contractor, my lord.
It was 8 years, my lord, till for a distance of 26 kilometers, my lord. This is only for a distance of 26 kilometers, my lord. They've taken it for 8 years.
May I make one submission, my lord? The learned petition.
20, what is the prayer in the petition?
Yes, my lord.
But prayer, my lord, is for the completion of the entire work in NH 209, my lord.
My
Prayer
lord,
is at
the-
page
The
16.
petitioner is essentially attempting to implement a contract, execute a contract through this honorable court. My lord would see on every earlier occasion, I have placed material to show, which is also the petitioner has knowledge of, to show that the original concession had abandoned the project. After he abandoned the project, because there was 600 crores worth of loans involved in play, my lord, the senior lenders exercised their prerogative to substitute the concessioner. Thereafter, a substitution agreement was entered into and works have commenced. All of this has been
Who are
reported
you?
for this honorable court.
Who are you?
I'm a person, I'm a citizen, my lord, who travels on the same road, and I have lands in the same.
What is your last, these prayers are not fit for public interest litigation. Where are your affidavit?
My lord, the
Last
latest affidavit that I have filed, my lord, is on 4/7/2024. But
Page? 2 days, you are, he is saying, council is saying today some.
today I have.
12/7/24, my
Where
lord.
is last affidavit?
12/7/24. I've received it on 12/7.
4/7/2024 is when we filed it, my lord. My lord, I think it may have been filed on in. My lord would also have my memo dated 22/2023, wherein I have placed the endorsement.
Total length of project highway is 165 kilometer. Out of which 163 is, 164 is completed.
Completed. No, my lord. I'm sorry, my lord.
Yes,
Their
my lord.
affidavit, my lord,
Out of-
today, on 12/7, which has been handed over, they say, my lord, it has not been completed.
My
Lord,
lord,
may I request their affidavit be produced, my lord, para 7 of their own affidavit, my lord.
I am under instructions.
Lord, if they have completed, my lord, I will not press on this.
You
page.
stated what more you
My
want.
lord, 7th paragraph of their affidavit, my lord. I state that the balance length is to be completed is 0.240 kilometers, which is incomplete for the following reasons. So and so forth. So, my lord, this is the main stretch, my lord. Today also, my lord, the safety of this stretch, my lord, is
UG
questioned.
high tension line near Ravi Shankar Ashram needs to be relocated.
My lord,
110 meters. When do you?
My lord,
when will you-
my lord, the only
Then give
issue
a
that's
date, my
pending
lord, I
is
will
point
not-
number 1, my lord. Point number 2 and point number 3, I have instructions that they're almost
Completed.
completed, my lord. So and we've also stated that this scheduled work date of completion is 31st August. But in any case, my lord would see, I filed a memo on 20 February 2023, wherein I've placed on record the endorsement agreement dated 13/2/2023, whereby the original concessioner, because he had abandoned the
Which is
project,
that, coach? Which is that memo?
my lord, 22/2023, my lord.
What does it say?
I have placed on record the endorsement agreement that was entered into after the original concessioner had abandoned the project. So the prayers in the writ petition are effectively infructuous, my lord, because it was filed at the time at which the original concessioner had abandoned the project. But the substitution had not yet taken place because the bankers were choosing a substitute concessioner. 600 crores of loans are in play, my lord. So it's not as if we can just shut down that contract and start a new contract. So I have shown through all the memos and affidavits I filed in these proceedings, I have shown compliance with the terms of the contract, my lord.
Give that memo.
Lord, may I request, my lord, I've only asked.
There is nothing.
No,
is
I've
left
only
in my-
asked for the completion of the project. I'm sorry.
There is nothing.
I'm only seeking indulgence, my lord.
Can't
8
go
years,
dragging this.
8 years, my lord. 8 years has been taken for completion of this project, my lord. Now, my lord, it's in the last end of this project, my lord. If this court is not monitoring this project, my lord, this project would have not started at all, my lord.
We can't
Only
monitor
because
such
the entrance of this court, my lord, the project was
It is your
started.
it is your misconception that court should monitor all these things. Writ petition number 5524 of 2022. What is the petition? What is this? The present is a public. What is it? The present petition is filed by the petitioner, present petition was filed by the petitioner, who claims to be the degree holder in the Bachelor of Business Management and also the degree holder in the Masters of Business Management from the University of Pennsylvania. The petitioner is stated to be the proprietor of Sri Vinayaka Enterprises, which is engaged in the transportation business. With such capacity, paragraph, with such capacity pleaded, comma, the petitioner claims to be a public spirited person, and 6, by filing this public interest litigation, the following prayers sought by filing the following prayers. Is read direct bracket portion, directing the respondents to effectively implement वहाँ से entered into between 2nd and 7th respondent. Why this, the second agreement was
My lord, the original concessionaire had abandoned the project, my lord.
original contractor?
It's a contractor, had abandoned the project. So the senior lenders have the prerogative to substitute a concessionaire, my lord.
May I
Because
request-
1,008 crores is the total project cost, out of which
I had filed this writ petition, my lord.
60% has been disbursed by the banks, my lord.
Lord, I had filed this writ PIL, my lord, when the first contractor had abandoned the project, the entire work was stopped, my lord.
The subject matter of the subject matter raised in the petition is about development, maintenance and management of National Highway number 209, development of National Highway number 209, including the section design chainage from kilometer 287.500 to 458.420 kilometers from the existing chainage against existing chainage from 287.520 kilometer to 461.550 kilometer, which is approximately 170.920 kilometers. It is inter alia grievance that for variety of reasons, the project was undertaken at snails, SNAIL, snails apostrophe S, snails pace, PSE, and that the road was dug up, and during the monsoon season, the parts were left open, unattended, which resulted into water logging, etc. It was the complaint of the petitioner that because of the delayed work in the project, the road was left with huge potholes, causing number of accidents on the national highway connecting Bengaluru to Kanakpura town. The grievance was that the major construction work of the said road oblique highway could not have been left incomplete and unattended by the authorities, which was against public interest. Paragraph. In course of the hearing of the present public interest litigation, the court passed orders from time to time, which figures on record. It was pointed out that at one stage, the court appointed court commissioner who...
I'm here, Madam. Online, Madam. I was appointed court commissioner on 15/3/2023. I have submitted the report.
Any interruption during the course of the order will not be tolerated.
Sorry, Madam.
Yes. So what did you write? Court commissioner and the court commissioner submitted its report on 6/4/23. The report figures on record. Full stop. After the orders passed and the report was submitted, much water has flown in relation to subject matter. Full stop. Where is that endorsement?
12/7/20.
It may be mentioned that a memo dated 20th to 23 paragraph came to be filed by respondent 4, in which it was stated that the earlier contractor with whom the agreement, the earlier contractor with whom the agreement was contract was executed for the construction, for the work of road construction, has left the work. However, the new contract dated 13/12/20.
13/2/23.
2023.
13/12/2022 has been executed with the new contract, and that the new contractor was working at the site to complete the road construction at National Highway 209 from full stop. Having taken note of the said memo, the affidavit, the court was invited, the respondents invited attention of the court to the, where is that affidavit? Last affidavit
12/7/23.
filed
24.
by the Deputy General Manager into bracket technical and project, technical bracket or and project director, National Highway Authority of India. If it am fast, then tell. You are able to dictate, get the dictation. National Highway Authority of India, PIU, Ramanagar, in which the following is stated, amongst other details. Status report 1, small Roman, status report prepared by the independent engineer in respect of progress of the project, which is 2/4 planning of BRT Tiger Reserve boundary to Bangalore section of NH capital -209 in the state of Karnataka is produced on record. 2. It is stated that out of the total length of the project highway, which is 165.348 kilometer, 160, the work for the length of 163.94 kilometer has been completed as on date. The affidavit, the date of the affidavit is 12/7/24. Next. The Bangalore-Kanakpura section is developed as 4-lane section, whereas the remaining section of the highway from Kanakapura to BRT Tiger Reserve boundary is developed as 2-lane section, which is based on the traffic volume projections. Next, Roman 1, 2, 3. The writ petition, this petition pertains to the Bangalore-Kanakpura section. The length of this part of the project is 27.92 kilometer, out of which 27.68 kilometer has been completed as on date. Full stop. In other words, 99.10% work, which is the subject matter grievance of this petition, is completed. Paragraph. The next paragraph, regular. The affidavit, with regard to even as not subject matter of the petition, the rest of the part of the affidavit is also noticed by the court, in which it is stated that the balance length to be completed for the road construction is 0.240 kilometer, which is incomplete for the following reasons. Then 1, 2, 3. Star. Report 1, 2, and 3. With regard to the above reasons, from a learned advocate Miss
Shruti Chaganta.
so and so and so for National Highway Authority stated that what is shown to be incomplete in Roman small 2 and Roman small 3 above has been attended to, and the said part of the work is completed.
Almost
Full stop. The only aspect left in the total road of the length is the 80 meters, which is incomplete, since it is UG capital, high tension line near Ravi Shankar Ashram, which is required to be safely relocated. Even in this respect, comma, it is stated in the affidavit that the remaining work is likely to be completed on or before 31st August 24. Full stop. Taking note of this aspect, comma, it is expected that the National Highway project work will be completed as early as possible. Right. Full stop. Nothing more survives in the present public interest petition. It is disposed of. Connected applications will not survive in view of the disposal of the main petition.
This is seal number 15. Bharat Kumar S.
State in this matter.
Respondents Council.
15 is again PIL. What is it about?
That's this.
PA
Matter.
Lords, respect of an order
That may submit.
where.
minutes.
Sorry. Learned from.
That's an order passed under section 83 of the Land Reforms Act. That's that is at annexure F, page 109. Translation, my lord, is at page 111.
So you are for number 5.
Respondent number 5, the purchaser.
So entry is in your land is in your.
As I'll only said 2 dates. Lords, my purchaser, my vendor purchased the land on 20th of January 1975.
Your seller.
I purchased it from her in 1989. Lords, 20/01/1975 is when my vendor, that is Srimati Sangama Patil, purchased the land. 20th January 1975. She sells it to me under two sale deeds on 4/5/1989 and 18/5/1989. Two sale deeds.
4/5.
1989 and 18/5/1989. Two sale deeds, two pieces of land. In the meanwhile, my lords, proceedings are initiated by the Assistant Commissioner under Section 70 for violation of Section 79A and B, which was in existence in the Land Reforms Act. That's, my lords.
Tribal.
My lords,
What is this?
79A says, my lords, income prohibition
Non-agricultural.
against my vendor who purchased it in 75, and notice is issued to her on 6/6/1996 in respect of her purchase in 75.
Under section 79A.
79A and B, violation of 79A, 79B of the Land Reforms Act. By which time I had already purchased. My lord, she was represented by a counsel before the Assistant Commissioner. So I was not made a party because I had already stepped into the shoes. She died on 7/8/1996.
Who? Your vendor?
Yes, who was a party before the Assistant Commissioner. 7/8/1996.
Seven.
7/8, my lords. 7/8/1996. The impugned order of the Assistant Commissioner came to be passed on 3/3/1997, forfeiting the land to the government. Now, my lords, I, as a purchaser, was not aware because notice was not issued to me.
Who is the petitioner?
Petitioner, my lords, initially is styled as a public interest Jana Jagruti, because I filed, subsequently I go before the Assistant Commissioner because I had purchased. I get the mutation changed to my name, saying that I was not even heard. This forfeiture order is wrong. My lords, he is the amicus curiae. What happened, my lords? The petitioner filed it challenging the forfeiture where my name was mutated, a PAL is filed. That, my lords, the landowners, LR filed as individual writ petition before the High Court challenging the Assistant Commissioner's order. The learned single judge has set aside the Assistant Commissioner's order, saying it was one against a dead person and more so a purchaser. Now that's the issue. That is now settled because
This can't be subject matter of public.
there is absolutely no public interest in this, my lords. When the ಹೋಗಿದೆ ಇವಾಗ. How can it be? Because forfeiture order has been set aside. And now the provision has been repealed also. By an amendment, both the provisions have been repealed. Even pending cases get abated.
Which is that writ petition?
My lords, that we have produced along with our statement of objections, if your lordship comes to annexure R5L at page 90 of the statement of objections filed by the fifth respondent.
May I make one submission? As an amicus, my lords, I'll only point at one as. My lord, may I make one submission, my lord?
And today, there is an impleading application filed by my vendor's daughter.
No, my lord.
Says the sale made in my favor itself is illegal.
My lord, that
Because these are
I'll
separate
make one
subject matter.
submission. My lord, I'll make one submission, my lord. That order, my lord, which they are relying now, my lord, was obtained by me. That order, my lord, which was they are relying now was obtained by me, not my, that benefit then, my lord, may I submit this. I hope my mother-in-law purchased the property in the year 1975. Proceedings was initiated in the year 84 itself. My lord, my mother-in-law was pursuing the matter. In the year 88, my lord, the land came to be acquired. They say that they are purchasing the property after the acquisition for the BDA. My lord, that cannot be so. My lord, after that, I was not aware of this, all this sale transaction. I came to know about this 97 order. My lord, it's against a dead person. I challenged that order and obtained the order before this honorable.
They are not relevant for us.
My lord, may I submit this, my lord? I bow down to this, my lord. My endeavor is that, my lord. The proceedings has been initiated before the deputy commissioner in RP, my lord. I have filed an impleading applications. My lord, if not, my lord, I have been put to hardship, my lord, because this is my property. I have filed an impleading application. My only endeavor is that, my lord, before passing any order, my lord, I may be heard. The opportunity of hearing may be given to me, my lord. My lord, and also, my lord,
In
may I
view of,
submit this, my lord.
in view of the order dated 3/3/1997 having been set aside by this court
My lord, that was obtained by me, my lord.
in whatever it is, in 707406 of 21 writ
Please,
petition.
please, my lord.
These proceedings will not survive as the prayer
But
becomes
I'm
infructuous.
grateful.
Let's
But-
we'll sort out.
but-
We'll make one submission.
Obtained by me, I have filed the writ petition challenging that order. My lord, this property belongs to.
This is, you have no say in this
My lord,
process.
I have no say in, I am grateful, my lord.
You proceed,
My
pursue
lord,
that.
may
You
submit.
file appeal against the learner single.
My lord, a liberty may be granted, my lord, to the
We
deputy.
can't grant here.
No, my lord, because all pursuant to the order of this honorable court, my lord, proceedings have been initiated.
We are not exercising.
The order of this honorable court, my lord, proceedings.
No, Mr.
Came to be
Counsel.
initiated before the deputy commissioner.
We are
My
not,
lord, he may be heard, he may hear me, my lord, that is.
in this proceeding, we can't pass it out. Everything is open for you.
My lord, I am grateful. My lord, the order of this honorable court may kindly be seen, my lord. Why the public interest litigation, my lord, was because they claim that 89 was the purchase. In the year 2021, they challenged that order, my lord, after a lapse of 22 years. And my lord, without issuing notice to the LRs of the original landowners, my lord, they gave immediately within a span of 2 months, my lord, order came to be.
We are not concerned with your right. We are concerned with the subject matter of this petition.
The subject matter of the order.
Because of
my
this
lord,
PAL, my vendor's
after a lapse
relative
of
comes now to
25
challenge my sale.
After a lapse of 25
He
years.
may
of
challenge
their
whatever.
sale, my lord, they obtain an order. After a lapse of 25 years, they obtain an order before, with that too, my lord, without issuing notice to me, to the original landowners. That is the grievance, my lord. That is only grievance. My lord, may I request, my lord, kindly see the order dated, my lord, 25/9/2023. My lord, that was noted. The assistant commissioner and deputy commissioner hand in glove with the respondent number 5, my lord, obtained an order within a span of 2 months. The assistant commissioner did not ascertain as to the fact that against whom the order has been passed, that submitted against whom it has been passed.
Can at the best say that we are not touching the order of merits of the learner single justice.
And then,
This,
my lord,
we'll say that
one
in view of the-
observation, my lord.
We'll only say that the in view of the order passed in the writ petition, setting aside this 3/3/97 order, this prayer will not survive.
Please.
We have not gone into the merits of the order of learner.
That's all.
May I
I'm
make
not
one
coming the
submission,
way,
minutes?
my
As an amicus, it's my duty to bring it to your lordship's kind notice.
3/3/97, this will not survive, but we are not going into the merits of the order.
Like
My
3/3, my lord, may I submit?
You have no right to.
No, I have no right, my lord. It is my duty to bring it to your lordship's kind notice. One aspect, only one aspect. Only one aspect, my lord, I would like to. Only one aspect, my lord, I would like to bring it to your lordship's kind notice. The 3/3/1997 order is not questioned in this writ petition. What is questioned is an order passed by the assistant commissioner, the
But it will
subsequent
not-
order.
It will not survive.
Your lordships will have to say, with respect, I would say, the orders at annexures H and H1, page number 202, that benefit should not go to fifth respondent because these orders are passed by an incompetent officer. That has been noticed by the state government
We are
and
not taking.
a
we are saying
report
that-
is filed.
We are only saying that this proceeding will not survive.
That's
My
all,
lord, that
my
is
lord.
the
I am
reason
only
what
saying
the
that.
earlier order, my lord, the inquiry came to be initiated, my lord. My
Even said we should not annual to the benefit. Yeah, ಇದು ನಿಮ್ದು
my lords, one kind submission, my lords, serial number 96, my lords.
90.
96, my lords, 96.
96.
My lords, it's a matter pertaining to election, my lords. The challenge against the order passed by the learned single list. Election is tomorrow, my lords. Kindly, my lords, request, my lords, it may be taken up at 3:30 or 4, my lords.
I appear for the caveator, my lord. I appear for the caveator respondent number 1, my lord.
We'll take
3:34.
96 may be taken.
Great.
Two 30 matters, seal number 64. So Dalwai Venkatesh.
I make one request, my lords. We had filed, not adjournment, my lords. My lords, we had filed an application to implead MOEF, my lords. That may be allowed and it may be had tomorrow itself, my lords. We will go ahead with the argument. The
Let's- yeah.
reason I'm insisting, 1 second, sir.
So you have filed what?
That's we have filed an application to implead MOEF, Ministry of Environment and Forest, it's Government of India. It will help the petitioner and the respondent. It is not the case that, my lords, it would be in
Notice will have to go to the new.
my lords, it can be, my lords, in a similar matter, my lords, in that fish meal matter, my lords had allowed and they made a change immediately, my lords, and we can serve it on the council who's appearing for MOEF, my lords, and may had it tomorrow or Monday.
My lords,
Same
I make
2:30 itself can be.
I
We
make
have no
one,
objection.
my lord, this application is filed by the respondent. My lords, it is not me who has filed an application for impleading. MOF is not a proper and necessary party. My lord, this is a case where, my lords, EAC recommends, my lords, the grant of environmental clearance. Within 45 days, it has not been recalled. My lords, the environmental appraisal committee, my lords, grants recommendation. My lords may kindly take page 116. My lords, I'll not take more than 2 minutes. The experts committee of EAC, lordships at 116, my lords, second unnumbered para. Proposal recommended for grant of environmental clearance subject to submission of bank guarantee of so and so to CPVC prior to grant of EC. My lords, I have furnished the bank. This was on 9/11/2023. By 25th December
In
2023.
view of submission of learned advocate Mr. Mahesh Chaudhary appearing for the respondent Karnataka State Pollution Control Board. The Ministry of Environment and
Ministry of Environment and Forest, it's Government of
Yes.
India.
will be a proper party. Which will help, whose presence will help the court to adjudicate the controversy in the petition in wholesome manner. In that view, petitioner is directed to implead as register number 2, the Ministry of Environment and Forest.
Environment,
Secretary.
Forest and Climate Change, my lords. My application, there's an exact address. That's one Mr. Shiv Kumar appears for MOEF. my lords.
Ministry of Environment, Forest and Climate Change. Impact Assessment Division. New Delhi.
So notice as to.
Government of India, Government of India, Indira Paryavarna Bhavan, Vayu Marg, 3rd floor, Aliganj, Shorbagh Road, New Delhi. 3.
Lords,
That's
to be
we-
served on learned ASG or his office.
Carried out by the petitioner immediately. It will be open for the petitioner to serve the copy of the petition to the council normally appears. For
Let's
the,
let us let them serve all the entire set of papers, my lords, on the ASG's office. Let them serve a copy of it on ASG office, my lords. They will allocate
piece of the assistant solicitor,
additional, my lords.
additional solicitor.
Some,
What is that urgency?
my
Today
lords,
itself?
for me, my lords, around 700 workers are sitting idle.
They
They are
must-
holding on to the CFO.
Nothing will happen.
My lords, my difficulty, lordship, may fix a date, my lords, I'll serve it by
Fixing date 13th of July. 13th of August.
2:30, my lords, same time.
Yes, yes.
No, not 213, regular. Every matter cannot be taken up to.
No, my lords,
Other day, your lordship were kind enough to accommodate, therefore, my lord, similar request I am making.
If I had accommodated, it is withdrawn.
No, my lord, that's.
No. Yes.
Yes. For final disposal, Bill number 65.
Which is
For the respondent state in this matter.
I appeared for the respondent.
Pardon me, my lords. I appear for the petitioner in 65, my lords. Kindly pass over the matter, my lord.
No, no. What is this?
No, we are getting a discussion.
65 too, like.
Oh, that monument.
No, my lord, yes, my lord, monument. My lord, I got the superintending archaeologist to once again verify. My lord, there is no impact on our monument by the construction. But the only difficulty is we will have to do post facto approval, which you'll have, if your lordships direct, my lord, we'll take it up. Otherwise, that construction should have commenced after obtaining NOC. Your lordships may exercise.
Some report is there showing that.
I'm sorry, my lord.
Report is there about.
Yes, yes.
About non-impact of.
Yes, yes, I'm filing it. I'm filing the report.
Filing.
Intact report is there.
Then we just go through and pass order on 21st.
Very well.
Heritage impact assessment
How to
report. has
house
been
the
updated.
order. Just- Today is, on 21st we'll pass. Let it come. Learned, on behalf of respondent 1 and 2. Memo is filed. Memo dated 8/8/24 is filed, along with which report of the superintending archaeologist
Second respondent.
ASI Bangalore Circle is produced, which is taken on record, stand over to 21st of
I'm grateful.
August.
You need to have it not small.
I don't know.
It's repeated.
96 is that. Any other petition is pending?
Please, I'm so sorry.
Only these three. There are three petitions.
Excuse me, my lord. So sorry, I joined now. I joined little later. Excuse me for my delay in appearing. My lords.
These are the three petitions only. There are no other petitions.
That's the tender about the prayer for cancellation of the tender, my lords.
ನಮ್ಮ petition ಹಾಕಿದ್ವಿ ಇವ್ರ petition.
Because I am also.
Appearing in which case?
Both cases. ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು?
No cost list, what is? One more, please. My lords, if 65.1 is taken up, that will decide whether the tender is proper or not. If the tender is proper, then my lords may consider whether other things can be done. If the tender itself is totally illegal, the contractor has no right.
But first this will have to be cleared that there is no impact on the, then tender will come. in picture.
Please, but I only pray my lords may consider the tender aspect, because where the tender is actually given without any, without following anything, as if a private property, municipality has just given it to somebody. Somebody came with an application, they gave it. That may, if your lords permits, I have prepared list of dates, how it has been done.
On that.
As, please, man, please.
Around
That's
21st
most helpful.
21st same time, my lord?
I am very sure if the
21st same 2:30, my lord? Today it was in the 2:30. I'm grateful.
please, most grateful.
This is number 96, Mr. Naveen GS.
Appear for the appellant.
I appear for the first respondent.
Yes.
My lord, in this senior counsel has been engaged. I seek for a passover, my lord. I have sent the words to him. Senior counsel is engaged in this matter. Kindly pass over, my lord.
You are there. What is it about? Let us.
My lords, it's a matter wherein, my lords, the petitioner has challenged the rejection of nomination for the post of treasurer, my lords. For sixth respondent society herein, my lords. On the ground that the returning officer has not correctly interpreted the provision of law. Rule 14 AG of Karnataka Cooperative Society rules, my lords. The preliminary objection that was taken before the learned single judge is, my lords, when an alternative remedy is available under section 70 of Karnataka Cooperative Societies Act.
Election petition.
Yes, my lord, they
Very
should approach. My lords,
So you can either party can approach. What is the equivalent? You are for whom?
I'm for the elected candidate, my lords, elected office bearer.
I appear for the,
It has been already
We
decided.
know that law.
Apex court has already decided it, my lords.
Nomination. cannot-
my lord, it's not as simple as that. The endorsement question, that is rejecting my nomination is,
Will issue notice in this.
please,
No stay can be granted.
Lords, tomorrow, my lords,
Election cannot be stayed.
lords, but it is as per the. order
calendar of
the-
events have been announced.
In any circumstances,
Lords, the election, my lords, for the reason, my lords, for the reason that the learned single judge has passed an order and directed them to hold elections, they are holding elections, my lords. At the first instance, elections were held and I was declared as the elected candidate for the post of treasurer. That was challenged before the learned single judge, my lords. After allowing the writ petition, my lords, learned single judge, my lords.
so nomination was set aside.
Yes, my lords.
Your
Nomination alla, illa, no, it is not set aside.
Results were set aside, my lords. Election results itself.
Even
set aside.
result is also not set aside.
Kindly, my lords, at page number
We can't. grant stay.
35, my lords.
Even then we can't grant stay.
My lords, kindly, at
Amount to allowing your petition, number one. And secondly, it is very well settled that election process cannot be stayed.
lords, if it is
Please.
allowed, my lords,
Already the calendar of events have been announced, my
writ
lord.
appeal becomes infructuous. my
And for that matter,
lords.
We'll say this, the result of the election is subject to outcome review.
please, my lord.
Kindly, my lords, it may be taken up for the final disposal itself, my lords. All parties are, my lords,
Because my lord, even,
4 and responded 2 to 4 is represented by state itself, my lords. Respond number 6, my lords, I may be permitted to take hand summons.
my lord, for that matter, one submission, my lord. Even he also has participated in the meeting held for holding the elections, has, the resolution has been passed. He has also signed the minutes of meeting. Everything has been done, my lord, and the calendar of events have also been announced already. Returning officer is appointed.
Plainly, my lords, it may be subjected the outcome of the.
It's not only, please, my lord, as your lordships,
Subject to the outcome of this writ appeal, my lords, I may be permitted to serve the councils appear in the writ petitions, my lords, and the date may be fixed for final disposal itself. Because, my lords, the term is 7 more months, my lords.
Why you are coming at the last moment?
Lords,
This post of direct,
Lords,
post of
treasurer, my lords.
treasurer.
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 Yes, my lords, I was declared elected as treasurer, my lords. Yes, my lords, I was. Lords, kindly, my lords. Page 132, my lords. Yes, my lords, page 133, my lords. 133. Yes, my lords. Election of president, vice president, treasurer. Declaration of results of elected office bearers. At serial number 3, my lords. Yes, my lords.
No, declaration of result as such is not set aside, my lord. The rejection of my nomination based on a wrong interpretation of the statute, that has been set aside.
But
No, it is not set aside yet. Writ petition is allowed, fresh elections have to be held. Specifically, it is not set aside. Still, he is continuing till the holding of the elections.
it's page 35 may kindly be perused, my lords. 35 minutes. My lords, it has not been
No,
set
it is
aside.
not set
An
aside.
endorsement for rejection of nomination was set aside. Directed the returning officer to hold fresh elections, my lords. At Roman number 3, my lords, at page 35.
Please, that is set aside.
That is the rejection of nomination. At 3 minutes, the third respondent election officer cum deputy registrar of cooperative societies is hereby directed to hold the elections for the post of treasurer in the 5th respondent society between the petitioner and the 6th respondent. Yes, my lords. Yes, my lords. 70. Let's writ petition at page number 37 minutes, 39. It's prayer number 3 minutes at page number 45 has not been granted, minutes. Page 45 minutes that sought for setting aside of the declaration of results that has not been granted, minutes.
My
B. N.
lord,
Mahesh Chandram.
my lord, Even now I seek for a passover, my lord, because senior counsel is engaged in this matter, my lord. Please, my lord. Please. Please, my lord. I have already sent words. I may be. Please, my lord. I have engaged the senior counsel. My lord, I have sent words. He is in 25. He will be coming now itself, my lord. I have sent the words, my lord. Please, my lord.
Great.
Seal number 16. The Ganapati Bhatt.
IA for amendment has been filed for. I have filed IA for amendment, seeking, my lord, the insertion of one prayer. My lord, that's, my lord, annexure Z, which we have sought in the appeal filed under section 15 of the Stone Crusher Act before the regional commissioner. This order, my lord, is by inadvertently, my lord, is not challenged. The impugned order passed by the regional commissioner has been challenged. Therefore, I am seeking amendment to insertion of that prayer in the petition. IA 1 of 2024 has been filed before this court to seek.
IA may be allowed, my lord. He's seeking for amendment of the writ petition. Yes.
Amendment which I have sought is, my lord, IA 1 of 24. After first prayer, second prayer, the four. Yes, my lord. Page 3. Page 3, my lord. Para 3. After first prayer, before second prayer, the following prayer may be inserted, my lord. The issue writ of certiorari or any appropriate order quashing the impugned proceedings dated 16/3/2022 passed by the second respondent at annexure Z. This is the prayer which, my lord, sought for insertion in the petition as second prayer. Proceedings, my lord, which is, my lord, kindly see writ petition. I have sought, my lord, the order passed by the regional commissioner. That is, my lord, first prayer. Ink page number 20 of my writ petition. This is, my lord, the 11A committee has passed, my lord, the proceedings. On the basis of that proceedings, my lord, no communication has been issued to the petitioner. However, my lord, they have not renewed the license. Thereafterwards, I have approached this honorable court. This honorable court directed to approach, my lord, regional commissioner. I have approached regional commissioner by challenging these proceedings. Subsequent to that, regional commission rejected my lord, appeal number 2 of 2023, which is challenged before this court. Therefore,
My lord, my lord, my lord. Proceeding.
second respondent. Amendment petition also that.
My lord, I
But-
may be permitted to file my additional statement of objections, if any, my lord.
Much.
Number 17, Mr. Krishna S. Vyas.
Hearing for the petitioners in this matter. Petitioner has preferred a 1 of 2024, my lord, seeking for amendment, wherein he has sought to bring on record, my lord, sir, one map that has been sketched by the fourth respondent being the Hindu Religious and Charitable Endowments Department, my lord, sir. And also certain documents to support fact that, my lord, sir, the area which is circumscribing the temple, my lord, sir, belongs to the temple, and the respondent has proposed a highway on it, my lord, sir. Therefore, these documents may be necessary, and I have sought amendment to the facts as well as the ground on this aspect, my lord. Yes, it is a public interest litigation, my lord, sir. Here, the brief of this case is that if your lordships would recollect, the highway, my lords? Yes, they wherein, my lords, a Nagadevata temple is situated in the pathway in which the proposed highway is planned, my lords. Therefore, we had made a submission before this honorable court, and this honorable court, my lords, on taking the cognizance of that fact, had directed the respondent to secure instructions as to how the temple could be saved. And now, my lords, there is a categorical assertion by the department itself, my lords, wherein the area circumscribing the temple has been shown as a car street belonging to the temple. It is an integral part of the temple, my lord.
Submission, my lord. As far as, no, one submission, my lord. Lordship directed me to accept notice as far as respondent number 2 and 3. Quite order dated 5/4/24. Till date, I have not received any petition copy. Till date, I have not received any petition copy, including IA for amendment. Then as far as respondent number 2 is concerned, this particular stretch not belong to respondent number 2. This is, even though it is a national highway, maintained by the PWD department, state is answerable. So respondent number 2 is not a necessary party.
I will undertake to serve another copy on them.
IA for amendment also not served.
I'm sorry.
No,
But even IA for amendment also they have not served, my lords.
I'll undertake to serve on them.
and my name is deleted for respondent number 3, my lord. I am representing only respondent number 2, my lord.
R3, my lords, notice may be ordered.
Government.
Lords, insofar as R3, my lords, government advocate may be directed to. take
PWD
notice.
department, government, they can take.
Government, my lords.
PWD
Government
department
advocate may
belongs
be
to
directed to
state
take notice, my lords, insofar as R3. On an earlier occasion, my lords, my learned friend was directed to take notice.
Adjourned, still number 19.
I appear for the accused in this matter.
Mohammed Shan.
I appear for the accused in this matter. I filed my wakalat 2 days ago, my lords. I seek 4 weeks' time to file my reply, my lord.
Sir,
Reply.
reply, so selection matter, my lord. Selection matter, shorter date may be given.
Number 20.
I appear for complainant. My lord, they have complied partly, my lord.
Nivas V.
They need to execute 2 more sale deeds, my lord. Let there be 2 weeks' time, my lord. Because of the commotion in Muda, my lord, they are unable to execute the sale deed. My lord, they have partly complied. They have allotted 19 sites, my lord, out of which they have executed 17 sale deeds. 2 more they have to execute. Because of the, my lord, Muda, there is some commotion in Muda, my lord, therefore they are unable to execute. 2 weeks, my lord. 2 weeks. I may.
Since the previous officer, the accused here in blood is transferred to some other place. So now new officer assumed the office that I have to get instruction and I am examination. Since the accused is transferred from this. He is transferred to some other place. When last month, about 2.5. Yes.
They have complied partly, my lord.
Number 21.
My lords, we have complied the order, my lords. I may be permitted to file a memo along with the accounts credited.
It is not within my knowledge, my lord, I'll verify.
Lords, arrears of salary and earn leave encashment, my lords, both which have been credited to the account of the complainant.
The present complaint was only with respect to the arrears of salary. With respect of leave encashment is concerned, please, my lord, they had paid prior to filing of the complaint itself. But the document, please, my lord, which shows it is only with respect to the leave encashment.
Arrears have been paid, my lords, 9,82,222.
Not forthcoming
Documents
which they have produced along with the memo. Not forthcoming.
I'll, the last page, my lords, that is page 7, my lords. Lordship could see that 9,82,222 is forthcoming, my lords.
Tomorrow I'll seek inspection on this. Tomorrow.
Number 22.
My lord, the
G. Kumar.
connected writ appeals would have to be allowed in view of your lordship's recent judgment in the Dr. Anil Khurana case where the search committee decides HOD, head of the department.
I submit, my lord.
Lord, so those writ appeals are at item 42 and 60. Today, my lord, they are listed. If those writ appeals are allowed, my lord, then contempt would not survive.
No, my lord.
Lordship just,
Not in my
Lordship's
opinion.
judgment in that Anil Khurana case, Dr. Anil Khurana case, where your Lordship's held that this honorable court cannot sit on appeal over the search committee's decision. Leader wala. This is exactly.
But for the definition of leader, your lordship, my lord, para 20, may I read, my lord? Look, the workload of Ayush Department, Government of India, allocation of business rules 1961 provides for organizational setup. The same is reflected at page 433 of the appeal. As per the allocation of business rules, the assistant director is having independent control over the particular division. When the organization setup does not provide for head of the department, it is for the court to examine whether a particular post would be head of that division. On consideration of the organization setup in that view, assistant director, though in the rank of, though below the rank of director general, the work and responsibility entrusted to the assistant director are independent. But here it is a case where he was working as an officer in charge, not as an assistant director. Kindly see, in this case, my lord, the lordship may kindly see the appeal page, their own document, my lord, which shows that he was working only as an officer in charge.
Oh, very well.
Lord, page 343 of the appeal.
Fourteenth, very well. Lord, along with item 42 and 60, they may be connected.
Number 23. Then MBBS. Writ appeal. Writ appeal field.
The writ appeal is filed in 313, my lord, of 2024. I think, my lord, it will be tomorrow. My lords can tag along with this. Tomorrow. Please, to be tagged along with
313. Writ appeal.
313 of 2020. 313 of 2024.
Number 24.
Lord, insofar as this matter is concerned, my Lord, I take notice. Yesterday I have received the papers, my Lord. I request for 4 weeks' time to file my reply. In the meantime, my Lord, may I make a submission? Second accused, my Lord, has retired long back. Therefore, I have given the name of the present person who is occupying. They'll have to amend the. Yes. May 2023, he retired. Number 25. Rema.
Lords, I pray for some time.
Number 26.
Here again, my lords. This is with respect to 7th AICTE pay scale. Lords, we have sent it to the finance department. I pray for 3 weeks' time. 20.
It's number 27.
For the petitioner in this matter, my lord, I pray for some sort of accommodation in these matters, my lord.
Number 28.
I am for respond number 4, my lords.
This is a PIL filed by the residents of the society on the ground that at page number 24 is the layout map of the layout, which is named as corporation layout plot at page number 24. There are 3 civic amenity sites. There are 3 civic amenity sites which are particularly earmarked for dispensary, post office and primary school. Now what has happened, Lord? Page number 24, just above part laws at the center. Post office, dispensary and primary school. Just above post office. And next to that is primary school. Specifically, it is earmarked for these 3 purposes. It is not simply said that it is a civic amenity site. This being the case, respondent number 3, Urban Development Authority, has given this property to respondent number 5, which is the Social Welfare Development Department, for construction of a community center. And I am told the community center is already to some extent constructed.
My lord, it's for that reason on 1st of April 2024, my lord had said construction of this Samudaya Bhavan shall be subject to the result of this writ petition.
Next B is the order of the Deputy Commissioner for allotment to the to respondent number 5. Hello, section.
Yes, my lord, on 1st of April 2024. My lord may grant me some time, my lord.
No, Milord. That's not a part of any plan. Because they did not, because respondent number. Please, my lord. Layout is formed as per the Karnataka Urban Development Authorities Act.
My lord, there was no government site, my lord, available for construction of this Bhavan.
No, Milord, Kalburgi.
I appear for the Deputy Commissioner.
Appear for respond 3 laws. 3. Global Development Authority. I filed my statement of objection also. I filed my statement of objections. Because your lordship, immediately the layout was approved in the year 1999, lordship. 1999, the state layout was approved by the government of Karnataka. The same site number 83, part of the layout was approved in the year 1999, lordship. Till more than 23 years, lordship. The central government has not approached this one 3 for allotment of the state CS site for the post office, lordship.
Competent enough to argue it. What makes you to advise her? Yes, there was provision you are changing the reason.
Your lordship, I produce annexure R3. Annexure R. Yes, annexure R3. Annexure R3. Annexure R3, lordship. Your lordship, under the allotment of civic amenity sites rules 2016, lordship. My one of colleague will come from Gulbarga, lordship. One of my colleague will come from Gulbarga and argue the matter. Gulbarga. Pray for some time, lordship, accommodation. Yes. Calvary, lordship. Your lordship, annexure R3 plus annexure R3 also. Annexure R3 may kindly see, lordship. Please. Much.
Sir, that will be stayed.
Provision under which the reservation make assessment.
Question number 96. Naveen Gudipate. Naveen. Naveen Gudikote.
Please, my lord, he will come, my lord. I have asked him, I have requested him, my lord. Please, my lord, please.
This December 29. Gautam.
I pay for the petition, my lords. Thus, I seek for short accommodation in this matter. I seek for short accommodation in this matter, my lords. As the standing council is now unwell, my lords. Standing council is unwell, not able to appear with me, my lords.
29.
29, my lords. Serial number
29.
29. Please, my lords. Please, my lords.
Please, my lord, I am appearing for the election commission. My lord, they have sought for some certain directions. No urgency. Objection already filed.
Number 30. Vidyar Mohan.
This is a PL matter wherein I have sought for a direction to the respondents to consider my reputation for completion of the road construction between Bhavani Bichalgaon village and Mudholbi village. It was abundant when it was halfway through. On the last date of hearing, my lord, the learned government advocate sought time seeking that she will get instructions from the department.
Lord, my lord, we have to acquire land, my lord, to complete this 2 kilometers road. My lord, and a bridge is to be constructed. My lord, the total cost will be 3.5 crores. My lord, and for that we have sought permission.
Yes, madam. No state, it is not state highway, madam. It is a road between two villages. Yes, ma'am.
I will place them on record. My lord may grant me 2 weeks' time. Lord, it's time consuming because land has to be acquired. My lord, I'll place what. Oblige.
Number 31. So Mahendra Kumar Mitra, party in person.
No order.
My lord, at least interim order may be granted, my lord. Notice was issued in the month of, notice was issued in the month of April, my lord. At least interim order. My lord, already this matter has been settled by the apex court, my lord. Only the procedure is to be followed, my lord. National Commission for Scheduled Caste, that is nothing but the respondent number 4 has given clear directions to the respondent number 6 to forward a proposal, my lord. This is only the case, my lord. If they send, yes, sir. Yes. Number 96.
Page 45, that sought for the prayer of quashing the declaration of results, my lords. Page 45, prayer number 3, my lords. Quash annexure K dated 2/3/2024, declaring the results of the election of office bearer for the respondent number 5 society insofar as the post of treasurer.
But that relief has not been granted, my lord.
Yes,
Please.
Okay.
But no order has been passed with respect to setting aside of that election. Only thing is my nomination, which has been rejected on the basis of a wrong interpretation of the statute, that has been set aside, my lord. Please, my lord, when there is a question of interpretation of law, my lord, if it were to be on the facts, yes, it is 70 days. My lord, 1 minute, my lord, please bear with me, my lord, please. My lord, my difficulty is that I can't even go on with the matter. I have engaged the senior counsel. Now it will not be fair on my part to argue the matter, my lord, on my own. That's the. My lord, another 10 more minutes, my lord, please, my lord, I request. Please, 10 more minutes, my lord. Please, my lord, then I may be permitted to make my submission, my lord. I request. Please. I appear for the first respondent, my lord. It is the petition filed by the first respondent herein which has been allowed, wherein I have sought for quashing the endorsement rejecting my nomination on the basis of a wrong interpretation of the statute, that is 14 AG of the Cooperative Societies rules, which clearly states that no director my lord, two persons cannot be proposed for the same post. That is what the provision says. That has been wrongly interpreted that a person cannot propose two persons for two different posts also. Now the nomination of mine has been rejected on the ground that the one who has proposed me has proposed a candidate for the post of president, not for the post of treasurer. If at all that interpretation has to be taken into, then the returning officer has accepted the nomination of both the sixth respondent as well as another person who has been proposed by the very same proposer. With the application of that principle. Section, rule. 14 AG. 14 AG. Rule 14 AG. In that clause 5 says clearly, my lord. Rule 14 AG of the Karnataka Cooperative Societies rule.
Minutes. 70, my lord, section 70. Section 70.
70 is dispute which may be referred to register.
Please.
Kindly, my lords, at
Here I am not disputing the election. What I am disputing is the rejection of my nomination, my lord. That is my main grievance here.
70C, my lords.
By virtue of the wrong interpretation of the statute, my nomination came to be rejected.
Any dispute arising in connection with the election of a president, vice president, or
Where
any
is that?
office bearer or a member of the
23?
board of society.
73.
70C, my lords.
73 is liquidated.
70 subsection C, my lords.
It's under the act. This is rule, my lord, what I have. Section 70C of the act, my lord. Karnataka Cooperative Societies Act.
Constitution, management, business. Election, challenging the election. It must be there.
My lord, I would like your lordships, I'd like to take your lordships to Rule 14 AG Clause 5 of the Karnataka Cooperative Societies rules, my lord, which says, Clause 5 reads as follows. No director shall propose or second under sub-rule 4 more than one candidate for the office of the president or vice president or any other office bearer of the society. This is what the provision says. But here, the first respondent who contested for the election was being proposed by one person. And the same person proposed another person for another post, not for the same post. And here the section says that, the rule says that it does not prevent any person to propose two different persons for two different posts. It should not be for the same post by the same proposer. Two candidates shall not be proposed. That is what the rule says, my lord. But misinterpreting this rule, my nomination has been rejected on the ground that the proposer has proposed me for the post of treasurer, has earlier proposed some other person for the post of president. That is the reason why my nomination came to be rejected. And it is in this context that I am before this court to seek interpretation of this statute. Whether this rule says that no person shall propose any persons for any other post if he proposes one person for a post. That is not the intention of the legislature, which has been decided by the single bench, my lord. Moreover, existence of an alternate remedy under section 70 clause 2, 70 clause C itself will not bar this honorable court to interpret a statute. Here I am not disputing the facts, my lord. What I am disputing is the rejection of my nomination based on a misinterpretation of this particular rule, my lord. And that endorsement has been quashed, holding that this is not the rule this is not what the rule says.
So hard learned advocate, Mr. So-and-so for the
My lord,
appellant.
I'm sorry, I'm very, very sorry, my lord. I should not interfere. I know that, but he came, my lord. Please, my lord, I'm very sorry. I should not, I'm not supposed to. Please.
Once the council is here, we'll.
Please, my lord.
to him. But only thing that the court is rising early, that is the only.
I'm very sorry. I should not interfere like this, my lord. I do
Right.
understand.
Only thing we are taking up is not to give the priority, but we are rising early at 4:20 or 4:20.
My lord, he is here itself. He came, my lord. I'm very sorry. I'm very sorry. I really request your
We are not
lordship.
giving any priority or not preventing your counsel to come, but we are rising early at 4:20 or 4:20.
Please, my
Therefore,
lord.
we are taking up. That is
I'm
the
not
only-
even supposed to make such submissions. I do understand, my lord. He's here, my lord. I'm
Please.
very sorry, my lord.
Sorry, my lord.
Yes.
My apologies. Judgment वगैरह question. Lord, may kindly have this.
ನಮ್ಗೆ ಕೊಡಿ ಒಂದು ಕಾಪಿ.
ಮಂಜುನಾಥ್ ಅಲ್ಲ ನಮಗೆ ಸಂಬಂಧಪಟ್ಟವರು. ಮಂಜುನಾಥ್.
Argument follow ಮಾಡಬೇಕು.
In the second page, my lord, your lordship may kindly see nominations filed for the post of president. In that, in respect of one Mr. Satish, seconder is Manjunath. Column number 3, seconder. In the nomination paper, seconder is one Mr. Manjunath. Then your lordship may kindly take the last but one page, my lord. Nominations filed for the post of treasurer, your lordship's got it. Last but one page. Page nation ಮಾಡಿಟ್ಟಿಲ್ಲ.
Yes.
In that, my lord, your lordship may kindly see, one Ms. Santosh Kumar has filed the nomination for treasurer. Proposer is Rajesh Gowda. At 158, another nomination is filed by Mr. Chetan, the present appellant. Proposer is Rajesh Gowda. Last is respondent. proposer is Manjunath. Now, an endorsement is issued saying your proposer has seconded a candidate in respect of the post of president. That was filed earlier. Therefore, your nomination is rejected. Similarly, your lordship may kindly see the present appellant, Chetan. For him, proposer is Rajesh Gowda. But returning officer did not find anything wrong with that being there. Kindly see the provision, my lord. No, other than that, there will be no other submissions. 14 AG. AG. Yeah. Sub-rule ಯಾವುದು? 14 capital AG. In that, sub-rule 5. No director shall propose. Lordship, got it, Mala? Sub-rule 5, my lord. No director shall propose or second under sub-rule 4 more than one candidate for the office of president or vice president or any other office bearer of the society. Provided that if any director has proposed or seconded more than one candidate for the office of president or vice president or any other office bearer of the society, the nomination which is received first shall be considered for scrutiny. The plain reading of this, all that it says is, in respect of the same office, there cannot be either proposer or second, more than one proposer or seconder. By chance, if someone has proposed or seconded to more than one nomination paper, the earliest filed should be taken. In my case, for the post of treasurer, Manjunath had not proposed anybody. Manjunath had not seconded anybody. None of these facts are in dispute. Therefore, we urged before the learned single judge that it is a pure question of law to be decided. Therefore, there is no reason to send us to Madam, ನಾನು ಲಾಸ್ಟಿಗೆ ಸೈಟ್ ಮಾಡಿದ್ದೆಲ್ಲ ಐತಿ ರಾಣ ಪ್ಲೇಸ್ ಯಾವುದು ಅದೊಂದು ಬಿಟ್ಟು ಉಳಿದವನ್ನೇ ಹಾಕಿದಿರಿ ಕಾಣಿಸ್ತದೆ ಚಂದಿಗರ್ ಮೇಯರ್ ಅಲ್ರಿ ಆರ್ಡರ್ ಕಾಪಿ ಒಳಗೆ ರೆಫರ್ ಮಾಡಿದ್ದ ಡಿಸಿಷನ್ ಯಾವುದು Learned single judge has referred to that decision, pointing out there are no disputed question of facts or anything in this case except a pure question of law to be decided. Your Lordship, may kindly go to page 19, para 6. Godrej. Godrej Sara. Kodri. ಎಲ್ಲೈತಲ್ಲಿ? ಎಷ್ಟನೇ page? Godrej Sara. Number it. Separate ಮಾಡಿ. Para 6, my lord. However, so and so submitted that Apex Court in a more recent case in Godrej Sara so and so reiterated another class of cases which merit consideration of a dispute at the hands of the High Court under Article 226 of the Constitution. It was held that if a case raises a pure question of law and if investigation into facts is unnecessary, the High Court could entertain a writ petition in its discretion, even though alternate remedy was not availed of. If the issue raised is persistently legal, requiring determination by the High Court, the parties need not be put through the mill of statutory appeals. ಶುಗರ್ ಬೇಕಾಗಿಲ್ಲ, ಅದು ಬೇಕು ನನಗೆ. ಕೋರ್ಟಿಗೆ ಕೊಡ್ರಿ. That is 2023 SCC online page 95, my lord. Only one copy, my lord. I'll just read out that and pass on, my lord. In para 8, it reads, what follows from the decisions of is that where a controversy is purely legal one and it does not involve any disputed questions of fact, but only questions of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of alternate remedy. Then, my lord, in para 21, in that case, factually it was pointed out that there is no factual aspects to be decided. It is only a question of law to be decided. On that ground, the petition was entertained. I'm sorry, my lord. There was some mistake in preparing this. Actually, para 4, 6, and 8.
Right. That's all.
Please.
In the election jurisprudence, it is more than a tried principle enunciated by catena of judgments of the Supreme Court that in the writ jurisdiction, the process of election, whether it is a grassroots level institutions of the panchayat or municipality, or even a democratic body like Cooperative Society, cannot be interjected. The only remedy to challenge the election is, as the statute may provide, which would be the election petition. Paragraph, learned advocate, Mr. So-and-so, is entirely justified when he assails the impugned judgment and order of learned single judge dated 16/7/24, brought under challenge in this appeal, that learned single judge has committed an error in granting relief and allowing the petition, which was a total interjection in the process of election. Paragraph, it was election to the post of treasurer of respondent number 5, Bengaluru Advocates Cooperative Society Limited. In the elections held in March 24, the petitioner was elected to the post of, declared elected to the post of
Appellant. Appellant.
Any interruption will not be tolerated, even if it is you are correcting the order. You are not supposed to correct the order of the court. We are in complete command of the facts. So please sit down. This is a permanent advice and instruction to all the advocates. When the court is passing the order, I am not going to tolerate any interjection. That is complete lack of etiquette on part of the advocates. When the court is dictating the order, interfering is not called for. It really disturbs the thinking process. Yes, what did you write? Slowly. Please to read slowly. Held in March 24. Full stop. The records unmistakably show, and it is an admitted position, that original respondent 6, the appellant hearing, was declared unopposed, and the necessary notification was issued in that regard. By filing writ petition, paragraph, under Article 226 of the Constitution, original petitioner prayed to set aside, prayed to direct the returning officer, respondent number 4, to accept the nomination paper of the petitioner for the post. It was further prayed to set aside the election. Set aside the declaration of result of the election, in which the appellant was elected unopposed. Learned single judge, paragraph, proceeded to allow the petition and issued the following operative directions. So page 35. 1, 2, 2, 3, 2, 3, 4, and 5. Full stop. By issuing the above direction and setting aside the order of acceptance of nomination of the petitioner, thereby interfering with the election process, which was already underway, prima facie, learned single judge committed a manifest error This is paragraph. In wake of the provision of section 70 into brackets regular 2 into brackets C, small c of the Karnataka Cooperative Societies Act 1959, which inter alia provides that any dispute arising in connection with the election of a president, vice president, or any office bearer or member of board of society shall be tried by the authority designated, full stop. The acceptance or rejection of nomination paper would be an issue clearly falling within the domain of election petition. When the remedy of election petition was available under the statutes, it was the only remedy and not the not the invocation of writ jurisdiction for the petitioner to seek the relief, which could have been done only after the completion of the process of the election. Full stop. A strong prima facie case is made out. Paragraph. Although learned advocate Mr. Kumar Patil or the respondent tried to submit that it was a pure question of law and the writ was liable to be entertained. Full stop. The decision which he relied on, this is from Supreme Court, which he relied on in Godrej Sara Lee Limited versus Excise and Taxation Officer from Assessing Authority, 2023 SSC Online SC 95, in support of the proposition he canvassed, did not relate to the election process, did not relate to election dispute. Full stop. When the issue of, when the question is of election, when the question is of challenge to the election or election process, it is well settled that the writ court will not exercise the jurisdiction and the remedy available to the aggrieved candidate is to file election petition only. Paragraph. Appeal is admitted. Full stop. As far as the interim stay is concerned, since the election process is already underway and the elections are scheduled to take place today, the court is not inclined to stay the election process. However, it is provided and directed by ad interim leave that the result of the election to the post of treasurer shall not be declared without the permission of the court.
And we permitted to serve notice to the councils appeared in the report.
Pardon?
And we permitted to serve notices to the councils appeared in the petitions.
You noticed, and the notice by the order is, the copy of the order may be served directly to the respondent.
Great. A date may be fixed for, a date may be fixed for display.
Appeal may be listed for final hearing on 21st October.
Great.
Serial number 89, my lord. Serial number 36 tomorrow.
Serial number 89, my lord. So appeal for the applicant for date may be fixed, my lord, for admission, my lord.
Will we keep it earlier, Mr.?
Serial number 36.
We'll keep it little early. 25th of September.
Please. Serial number 36.
Serial number 89, my lord. I appeal for the applicant.
Pardon?
Fix a date, my lord, if it's convenient for you.
All date will be given.
Serial number 36.
No matter in the board will go without date.
Grateful, my lord.
My lord, serial number 56, interim order may be extended, my lord.
All interim order. will-
Period number 58, my lord.
Yes,
A week time may be granted.
will grant. Photo.